Start it up. Afternoon session, y'all ready? We're about 2 minutes behind, so I'm gonna go ahead, start it up. Hit the like button on your way in. You guys did amazing with that earlier. You know your girl works hard. 3 streams yesterday, 1 down this morning. Here's our second one. Let's go back in. Do me a favor, hit the like button as you tap in, and let's continue on with today's trial. We saw Lil Woody pop in earlier today, so we are all really excited to see if there's a possibility of him continuing on. Let's hit play and keep going. I'm gonna skip ahead because it looks like we have the beautiful seal in the state of Georgia.
We got everybody? All right. All right. What I know about Mr. Melnick at this point is that he is going to be available by Zoom 3-ish, and I didn't talk.
Guys, that's huge. All right. If you're just now tapping in, Lil Woody was available in the courtroom today, and the judge had to put a pause on everything because we needed to see if we could get John Melnick in there. Lil Woody has the understanding that John Melnick is still his attorney, and guess what? We got Melnick today. It's going down, guys. That means that we could hear from Lil Woody after John advises him. So do me a favor. As we're tapping in for this afternoon session, type in Lil Woody, hit the like button, get your popcorn, relax. If you're at work, tighten up headphones. I got you guys, and all my jokesters in the chat, they are back in the building. Let's go.
My lit manager talked to him, so I'm not sure we have a super clear answer on whether he currently represents Mr. Copeland, but Mr. Melnick was going to reach out to Mr. Copeland, and maybe by the time we hear from Mr. Melnick at 3, we'll know the status of that representation.
Thanks, Tyree.
All right. Yes. Am I cold? Is the court cold? No, the court's never cold because these robes are really heavy and hot. So no, but I mean, I realize that it is probably objectively a little cold in here. So I might nudge it up a half a degree for y'all. And then if y'all, hang on.
Running off the bench.
Now, there are 2 other thermostats somewhere in this room, and if y'all want to nudge those up, somebody just go back there and do that. That's fine. Okay.
What you mean, Troy?
All right, so we were, I think, on item number 20. Were you able to look through any more of them? And
so what I was doing was the other assignment, which was to look up the law and look up what we should tell Ms. Copeland. I don't have.
Oh, perfect. Yeah, that's probably more pressing. So, okay. What do you know on those?
So
I did these crimes, Law RM.
Is part of the basis, well, actually was the basis for the interpretation that we had regarding.
Okay, let me get maybe to the statute. Give me a second to get on Lexis. Unless you have a copy of it for me.
I don't have.
That's fine. It'll just take me a second to get it pulled up.
Talk about being unprepared when the judge has to pull up statutes for herself.
So you're talking about 24.5.507?
Yes, Your Honor.
Okay. All right.
So just the plain language of the statute,
The judge is reading the statute. This is why you need to have it prepared for her.
So, just the plain language of the statute, Your Honor, which is essentially a statute not saying that, the court can grant immunity, but that the state can grant it and we have to move the court. It lays out very specific steps that we have to take.
Hang on a second. Can you not hear her?
Nope.
All right, can you, I don't know, do those mics move?
It wasn't on.
Okay,
It wasn't on.
there we go.
So as I was saying, the language of 24.5.507 lays out very specific steps. Only the state can grant immunity, but the court can compel the testimony, which we obviously can't do. And 24.5.507 is a statute that allows us the leeway, the grounds rather, the pathway to get a witness to testify after they have pled
Right.
the fifth. And so section B of 24.5.507 says, if a person refuses to testify after being granted immunity from prosecution and after being ordered to testify as set forth in this section, such a person may be adjudged in contempt and committed to the county jail until such time as such person purges himself or herself of contempt by testifying as ordered.
Actually, you know what, guys? I'm going to rewind. What she's talking about is huge. Okay. This is, I don't know if you guys remember that outstanding law we were talking about before we went on the lunch break. Here's what that outstanding law is. Lil Woody is back. John Melnick is scheduled to join us in about an hour and a half at 3 p.m. Eastern. Okay. We had Lil Woody today and he was confused on whether or not he was represented. The judge fixed that. She corrected that wrong by making it clear that we will not move on unless Woody knows, in fact, if he is represented or not. Then during the lunch break, she did tell the prosecution team, hey, because one of the questions that Lil Woody had, the question that he had, the main one was, do I need, like, if I do not testify, if I choose not to testify, because if we look at the ex parte hearing transcript, the way that Glanville, Love, and Hilton posed it to him back in June, on June 10th, they said, Woody, if you do not testify, okay, we're gonna hold you in contempt and you will go to jail and you will stay in jail until this case concludes and every severed case of any defendant concludes. That's a long time in jail. All right. Now, the judge, Judge Whitaker, the new judge, does not believe that that is in fact accurate. So what she asked ADA Love to do, or CDA, sorry, I keep saying ADA. She asked CDA Love during the lunch break to do research on that statute to ensure that it is true. She told Lil Woody, the judge, meaning she, because y'all know this, them, they, all of that. Judge Whitaker told Lil Woody, hey, and Lil Woody asked, like, hey, if I choose not to testify, am I going to stay in jail just for this trial or for all the other defendants as well? Judge Whitaker responded and said, just for this trial. And then she looked at CDA Love and said, go do research to make sure that that is accurate. That is the first thing we're getting to post the lunch break. So I am going to bring it back a little bit because this is actually super important to what we're going to see towards the end of the day. So I'm going to go back to when DA Love gets her mic on in just a few seconds here. And I want to see what statute she's talking about, because here's the thing. She didn't have a copy for the judge. That's why it was quiet for a moment there. I don't know if you guys see her in the screen. She had to pull the statute up herself. Okay, so let's see. DA Love's getting up and she's going to let us know what the result of that is now.
So just the plain language of the statute, Your Honor, which is essentially a statute not saying that the court can grant immunity, but that the state can grant it and we have to move the court. It lays out very specific steps that we have to take.
Hang on a second. Can you not hear her? All right, can you, I don't know, do those mics move?
It wasn't on.
Okay,
It wasn't on.
there we go.
So as I was saying, the language of 24.5.507 lays out very specific steps. Only the state can grant immunity, but the court can compel the testimony, which we obviously can't do. And 24.5.507 is a statute that allows us the leeway, the grounds rather, the pathway to get a witness to testify after they have pled
Right.
the fifth. And so section B of 24.5.507 says, if a person refuses to testify after being granted immunity from prosecution and after being ordered to testify as set forth in this code section, such a person may be adjudged in contempt and committed to the county jail until such time as such person purges himself or herself of contempt by testifying as ordered without regard to the expiration of the grand jury. I don't know why it only references the grand jury and not a petite jury, because the top portion of the statute in section A refers to both. And it talks about the fact that if you're needed in a criminal proceeding before a court or a grand jury, if your testimony is deemed by the district attorney necessary to the public interest, then the DA may ask the court to compel that person to testify. In any event, the last line, which says that if the grand jury before which such person was ordered to testify has been dissolved, such person may purge himself or herself by testifying before the court. I don't have the reason that they refer to the grand jury. And
Sorry, I
don't
just put
reference the
members
trial
only
jury.
on, guys.
But given the fact
I was muted, but I'm just saying it's such an important day. Y'all got my likes looking raggedy. All I need is 400 more. All I need is 400, half and half ratio. So I'm pulling something from my mentor. It's the first time I've ever done this on my channel, and it is in members only. Sorry, guys. Just give me 400, and yeah, we'll go from there. Sorry, I was muted, but let's keep going.
fact that the statute itself refers to them almost interchangeably in section A when they say if you're either brought before the grand jury or a criminal proceeding. And so the fact that even after the grand jury is dissolved, the court can keep you there until you purge yourself of the contempt by giving the court testimony. The extrapolation that I made was you can be kept until you purge yourself of the contempt by testifying, because you don't have a right to assert your Fifth Amendment privilege.
Right. So one thing I would wonder about with regard to that argument is it's sort of a kind of basic canon of statutory construction that if certain language is used in a part of a statute and then it is not used in another part, that there's a reason that it's not used, that there's some significance to at one point saying before a court or grand jury, because they clearly knew they could use different language. So the fact that they didn't include it all in the second part, there might be a reason for it. So that I think kind of cuts against the argument that I can hold Mr. Copeland throughout all three trials.
Wow.
So I think we need, if there's some sort of case law that indicates that if the testimony at issue is before, like for a trial, that somebody can be held even after the trial is over until such time as they decide to come testify in front of a court about it. So
someone sent me a case, but I haven't fully got it. It's in Long, 276 Georgia App 306. I'm reading it.
Okay. And if anybody on the defense side of the room's got a case that says the opposite, then that would also help us out. that answers the question the other way. It just seems to me like if he's under subpoena for a trial, then
Yeah, we're
the
deciding.
point in which it would
We're deciding
logically
right
end
now.
would be when the trial is over. And I get he may never still purge himself of the contempt, but I don't know.
Yeah, the judge is not buying that argument. She doesn't want to keep Lil Woody in for 3 trials. It's crazy. She wants to keep him just for this one.
And it's a 2005 case, Judge, so I haven't looked carefully at it, so I don't know if it's cited in the annotations.
It is for a different proposition. I haven't read it myself either, but
Y'all almost there with the
I
left.
don't know that
Good
this
job.
case really answers the question we're asking. Anybody have any other kind of case? I mean, my position without a case to say it clearly one way or another is I sort of feel like it couldn't go past the end of the trial.
But it doesn't say.
But I know that. I mean, one way or another, I'm willing to be persuaded differently if we've got law.
Your Honor, I don't have a case on point, however, it would make logical sense that it couldn't go past the end of the trial, how Mr. Copeland purged himself of contempt. of
Standing in for Weinstein.
Yeah, I mean, I guess the same way that they suggest that if the grand jury is over with, you can come purge yourself by testifying in front of the court. Not that either of those really achieves the end that is sought by the immunity order, but it's a way to purge. But,
And arguably, the testimony would be under oath and available. I'm
it was not going to be available at, I mean,
not at that trial.
Right.
Yeah.
so I'm sort of going with through the end of this trial unless somebody tells me differently.
I agree. I don't think you should do more than that. If it's not, if there's
All
no
right, has
law,
anybody come up with anything else that he ought to be advised about?
Your Honor, I know that the court did advise him that. Westmoreland, can you hear me? I know that the court advised him that he was told some things that were not entirely accurate. And just listening to the testimony and looking at the transcript of what he was told, as the court sits now, are there particular points that the court has concerns about? Because regarding perjury, the statute sort of
Yes.
lays it out. And I know that before he testified, the last time, Judge Glanville, I think, gave him a
Gave
copy of.
Ms. Bumpus to give to him, I think.
No, actually, while Mr. Copeland was on the stand, I think.
Oh,
that-
in court.
Yes,
Okay.
he gave to Mr. Copeland, read to him or gave it to him a copy of the statute and apprised him. I think he made.
Okay, right, but all of that was before the ex parte. Y'all, it's already too hot, so I'm gonna have to turn it back up.
listen, we want Woody free. We want.
I would
Yeah, you want to be
love
free?
so I'm seeing
200
that
likes.
I have to agree.
200
will
likes.
Make a difference.
I will survive. So
What were we saying? Oh, yeah, so that was in court, but then the ex parte occurred after that?
It
And-
did.
And much closer in time to when he ended up testifying. So I'm thinking that probably was well, who knows, but that may have been the thing on his mind at the time. So one thing, and I mean, there's, this is He comes in on page, at 10:03, and it goes until 11:30, and I mean, there may have been a break or two in there, but so I realize that it's not just he's told one thing at one point in time, and that's really unclear. I mean, it may be that the gist of it gives him the right information, but for instance, I know there was one thing about perjury that I didn't think was exactly accurate. Just as an example, if I can find it. Okay, so on page 51, the example, and I know what Ms. Hilton means. I don't think that anybody is purposefully trying to mislead anybody. I think we're all, you weren't there by the time Mr. Copeland came in, but I think Ms. Bumpus, Judge Glanville, and Ms. Hilton were trying to make sure he understood. But Ms. Hilton says, your example that you gave me, what if I said I did something and I know you didn't do it, and you said before you didn't do it? That's not perjury. That is a prior inconsistent statement. Well, I mean, yes, it's a prior inconsistent statement, but it might also be perjury.
Yes.
It might not be, but
Yeah.
I mean, yeah, there'd have to be some, proof that it's a lie. But to say that's not perjury is technically not necessarily correct. And you're also talking to a layperson. And he clearly, I don't think, understands. I mean, he even says, I don't understand any of this.
Right. And that's the thing, guys. As we're reading this, and I have the transcript over here on the other side as she's talking about it, we're going back to that June 10th conversation and what the DA's office said to Lil Woody. He was a little confused about, because he was asking a lot of questions. He was asking for clarity about, if he gets put into jail, how can he cure and get himself out of jail? And they said the only way you can get out of jail is if you provide testimony, if you testify, right? The judge that is presiding now, Judge Whitaker, I think is actually being a little fair here, because the prosecutor is trying to convince her that he can be held after this case, meaning, and Glanville said that. So I think that's why she is very, very particular with her words here. But also at the same time, she's going back through the transcript and she's reading what Lil Woody said and what Simone said, right? Simone is not there today. She's on vacation, guys. So she's not here for this conversation, but we are now we're backtracking and we're looking at it line by line, seeing where Lil Woody was confused about things. And Judge Whitaker does not even want to talk to him until those things are abundantly clear, because Woody's going to ask her those questions. He was just here about an hour and a half ago asking similar questions. So she wants to make sure it's very, very clear that she gives him proper information. And because the state did not properly advise him, she wants to make sure that we do this right moving forward. And if Melnick is joining us at 3, we need to make sure that he has the right information to give to his client. Let's keep going. And good job with the likes, guys. You're almost there. 300 more.
At the outset. And, we're talking about purge versus perjury. And I just think we need to make sure we give him clear instructions and then he can make a decision.
Yes, Your Honor. And I know that I think I said on the record regarding his attempt to sort of get that information before he took the stand, when he was trying to speak with Ms. Hilton out there in the foyer area.
Yeah. And then, we also discussed the immunity versus statute of limitations. And yes, the immunity, because he has been given immunity, protects him from being prosecuted based on anything he says, if he says anything. And that is true. But he was also sort of told, you don't have any statute of limitation worries either. And that's not necessarily true. And it may have no practical effect, because if he can't be prosecuted, he can't be prosecuted, even if it's for something within the statute. But it was technically not necessarily 100% accurate information. Whether he in any way relied on that, I'm not saying that at all. But I just want to make sure we do it entirely, to the extent we can, correctly and accurately.
So would the court be inclined to read him the statute and then respond? I don't know. I'm asking. Respond to questions because, for
Sure.
instance, I even heard, it may have just been a misstatement. Obviously, and people communicate differently, but when Mr. Melnick was saying regarding how his testimony couldn't be used, but we could use the testimony we can't.
So I don't know. Some people keep saying he's got use, and then some people are saying he's got use and derivative use. So I probably need to look at the order.
I wrote the order and I literally modeled it after the exact words in the statute. Like I took the statute and put it in the order for the most part. And so the part of the statute that says that no testimony or other evidence required under the order or any information directly or indirectly derived from such testimony or evidence shall be used against the person in any proceeding or prosecution for a crime or offense concerning.
That sounds like derivative use to me.
And so that, that was in there from the start. And
all right. And yeah, do you want to, what's the perjury statute?
I will look it up.
And frankly, I'm not sure that either giving him or reading him any of these statutes is going to be particularly helpful, but that's why I would like for him to have counsel, so counsel can explain to him, here's what the perjury statute means. Here's what your immunity order means. Here's what a prior inconsistent statement is. Here is what you face if you decide not to testify regardless of your immunity. And then, sure, if he has any questions of the court, still we can entertain those. But
and I don't know how wise it would be to even make the request that if his counsel seeks to understand the extent to which the immunity exists, like if he would speak to us, but
well, maybe we can dial down from all of that too. That's been several weeks since y'all all made, assertions about whether or not who knew what when and who was professional and who wasn't. And maybe I'm going to ask Mr. Melnick and you to move past that. And
I'm beyond it.
You're beyond it. Great. We'll see if he is.
And I would love to be able to fully explain, to allay any fears that he has or concerns about his client's criminal exposure, but 161070 is the perjury statute.
Okay. And then I ought to know prior inconsistent statements by heart, but which one is that? 24 something. I don't know. I'm sure I have it in front of me somewhere, but.
So they're pulling the
I
law.
think those would be the four relevant things: the order 507, perjury statute, and prior inconsistent statements.
So they're pulling the laws to explain this to Woody today, guys.
Whatever, I'll figure it out later. I can find prior inconsistent statements.
246630. Wait. Twenty-four 613. Witness's prior statement. 246613B.
So Ms. Pressfield's been doing some research, and at least the federal statute on contempt related to kind of their version of immunity is that the confinement can't exceed the life of the court proceeding. So that's sort of, I know we're not the feds, but.
Is court proceeding the indictment, or is it the trial of a severed, because if people are severed? Like
I don't know the answer to that.
Jen.
Yes. Yes, I don't, who said that? You did what? Say that again.
Email.
Okay, to Ms. Firstfield, okay. And do you have a short answer for me?
Yeah, we don't just hold people in custody. As U.S. Supreme Court cited in footnote 1 from the Middle District.
I think that's Adams.
Sorry, she was a deposition person.
Mhm. It's Steele, but we can't hear him.
Government's position is like the state of Georgia. Government's position is like the state of Georgia here. Just hold the person because the case is not resolved. And the Middle District, the district court judge gave reasons. And in the footnote, they gave the U.S. Supreme Court that the contempt is punishable for this trial. And after that, we don't do for other trials that are not set. And the government can't continue this contempt over and over again. They can bring an obstruction of justice indictment against the person or a contempt criminal charge against the person. But we don't just hold people because it becomes, and there's other case I can send you, at some point it becomes just punishment. The whole point of civil contempt is to coerce the person to do the act.
Right.
And at some point, they're not doing the act.
Yeah.
Otherwise, according to Ms. Love, I mean, you really, according to Ms. Love's reading, we could just hold them until it's 50 years
die.
later. Yeah.
Yeah.
I mean, at
Which
some
can't
point,
be the law.
Right.
And I know you're not arguing that,
So
but
the court permit me a moment to just review the case that Mr. Steele just sent over.
sure. Did you send it to everybody?
He did. I got
Okay,
it.
yeah.
I just want to read it.
And
Ms.
just
Matthews.
Similarly, is civil contempt, and I'm looking at In Re Estate of Banks. In Re Estate of Banks is going to be 339 Georgia App 144. It says under Georgia law, when the trial court orders incarceration for an indefinite period until the performance of a specified act, the contempt is civil. A trial court, however, may not continue incarceration for civil contempt when the respondent lacks the ability to purge themselves. Imprisonment under civil sanctions is always conditional, and a party found in contempt may apply for release at any time upon a showing of inability to
Okay.
comply. The moment it appears that there is inability, it would clearly be the duty of the judge to discharge the party, because the purpose of civil contempt is to provide a remedy and to obtain compliance. with
That
the trial court's
matches.
Orders. The justification for imprisonment is lost when the compliance is impossible.
Thank you. I think you have hit on the exact
That's
case
it.
we needed.
You
So
did.
that answers the question for me.
Perfect.
You can look all you want, Miss Love, but I think that pretty clearly answers the question. Logically speaking, that
Guys, I think that was attorney Adams who found a case that directly is on point with this. What does that mean? When a case is on point, that means the case has facts that are so similar to this that the answer is undeniable. So I think that was Adams that found a perfect case that fits this scenario where someone was held in contempt, but the answer to the question, can he be held in contempt beyond the close of the trial? The answer is no. And that is a case that is on point directly in the state of Georgia. So shout out to Adams and Thug's team. They found the answer to that question on behalf of Young Thug. So that almost means they're welcoming Lil Woody back on the stand. So we'll see what happens. But it looks like she is going to advise Lil Woody that he is not going to be held beyond the closure of this trial, not for the other defendants, this trial. That is a huge blow to Glanville as well and the prosecution team who advised Lil Woody otherwise. And that means what they said to Lil Woody was wrong.
That was kind of what I was feeling anyway, but now we got case law to back it up. Good deal. All right, so. So I am proposing that if Mr. Melnick is in fact representing Mr. Copeland, I ask Mr. Melnick to please make sure he understands the order, the scope of his immunity, which I read to be derivative use as well, and what perjury means, what false statements mean, what could get him either of those charges, legally speaking. And I know Miss Love, you and Miss Hilton had said there are certain things that even, okay, well, in your discussions conceptually with Miss Bumpus, but I'll leave it with Miss Hilton, had said, I am not intending to charge you with perjury if you do X, Y, or Z. I am intending to charge you with perjury if you do A, B, or C. And Miss Hilton's not here, but you could speak for the state, I would think, as to if there are certain things that you absolutely know, if you say this, and we know we have proof, whatever you need to establish perjury, that you're lying, then we do intend to charge you, if you know. If you get up and say something that's not material, like, the sky's red today instead of blue. I mean, it's not red, it's blue, but who cares? It's not relevant.
No,
Then
sir.
I'm not going to charge you with perjury for that.
And I think that was along the lines of what the intent was, but the intent isn't really an issue. It's the reading it. I'll just say I agree with what you're saying.
Okay. And, if you then say, I don't know, I don't remember, blah, 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 to whatever, every question we ask you, then we will impeach you with prior inconsistent statements. This is what this means. And you don't have to explain that. Mr. Melnick can explain all of that. But I would just propose to make sure that I ask Mr. Melnick to explain all of that. Then he can confirm, yep, we've done that. And then if he has any questions, we'll take questions. And I'm even happy to say, so when you get a jury question, we can huddle and go, I'm planning to say this. What do y'all think? If y'all want me to do that, or I'll just wing it either way. If y'all are fine with me winging it, I'll wing it, but don't wing it. Okay. All right. So that's kind of what I'm thinking we do at 3 or 3-ish or whenever we have Mr. Melnick available. And then maybe give him, assuming he is the attorney, overnight to fully advise him of everything. And then we'll have him in maybe first thing and find out what he's intending at this point.
John, I inquired the court regarding the court's earlier statements about the case that Mr. Matthew cited. When it talks about an impossibility, is the court's understanding of that after the trial is over, after this particular portion of this indictment is over, it's no longer possible to purge oneself?
It would no longer be if you said I'd have to have your motion in order in front of you, but as I understand the motion in order at this point, we need his testimony for this trial. Now, you may also need his testimony for some other future trial of some indictee in this indictment. I would think you would need to seek and secure another order. I don't have it in front of me. I can look again, but that's my read on this. I mean, you may never try another person. We don't know that. So how can it not be that, as far as you know, he's no
He
longer able
eating
to purge once
candy
this
or
trial is over?
something?
Theoretically, given Part B of that statute, would he not?
Right, I've made my decision and I get it, but I don't think that, I just don't think that supports your argument. So I think unless and until you can bring me more law, I'm done with it might mean with this part of it. Okay. All right, so let's go back to our narrowing down, figuring out what needs to be redacted out from these statements of Mr. Zachery.
John, I inquire one more thing. If Mr. Melnick intends to not represent Mr. Copeland, what is our position at that point?
I guess we can ask him, does he want an attorney? And I have inquired, because I don't know the answer, of the public defender's office, whether in a kind of situation like this, where you have somebody who could have been indicted, who's not currently indicted, who's been given immunity, assuming he would qualify for their services, could they or some conflict attorney provide representation?
Judge, I would tend to agree that seems to be the most sensible thing to do. I mean, at any point where someone's liberty is at issue, the court should at the very least inquire as to whether or not there's representation that can help a layperson, Mr. Woody is, navigate his way through these things. So I would agree with the court's inclination.
And if for whatever reason, no, a public defender or conflict defender cannot present a witness, although I would think they could because of what you said, as long as they qualify, his liberty is potentially at stake. But if they can't for whatever reason, then I don't know, we just have to.
And I would suggest that the court take it upon itself to do the best the court can to advise the witness appropriately without any input necessarily from either party. The court is less vested Mr. Copeland's testimony than either side. And so I think it would be the court's responsibility at that time.
What's certainly ultimately my responsibility, but I am soliciting from both sides whatever they think would be appropriate to advise him about. And I can then take it all and look at it and put it together. I'm not saying just because y'all asked for it, I'm going to advise it, but I would like your input on it, particularly given issues that have been complained about his prior advisement. So
Good.
All right. Okay, so let's turn to, somebody needs a bathroom break. So I know we just got back here 30 minutes ago. Y'all should have gone to the bathroom before then, but we'll take a bathroom
Wow.
break quickly. I'm just going to stay here.
That's crazy. These people need to like get their stuff together before the breaks and all of that. That's interesting. Have we been on for a half hour? We have been on for a half hour. All right. So we're waiting for people to come back from their bathroom break. I got a little bit of TiVo time. This is why I do this. All those people that complain, guess what? Guess what AV did? She got you back from the bathroom break. Shout out to me. Let's go. A little scuffling at the prosecution table.
All right, are we ready to turn to our potential redaction report? Should I take silence as a sense?
How about resignation? Because
Yeah. Fair enough. All right. So, and whenever.
I think her mic is off.
All right, so we're now going to be on page. We're now going to be on page 75, lines 10 through 78, line 1. Hearsay about Woody and who shot Boo, and I'll have to look at it. Oh, and by the way, I was, going to circle back and listen and look at the video on that one item, and nobody, to my knowledge, sent me the video, so I haven't been able to look at it yet. Can y'all?
I've uploaded, I should have neglected to inform the court, I uploaded that Dropbox link for recording. So.
I don't know if I still have that Dropbox link. I don't know. Can you just shoot me the link again?
Yes, sure.
Okay.
I try to keep the same link for the transcript, so I will resend that link. And then there's one long version of the video, and there's a smaller one where it breaks it into
Okay.
smaller chunks. I've used VLC to operate. I don't know if the court has that player on your system.
I think so. I think we have that one.
I will resend that on right now.
All right, great. Thank you. Okay, so let me.
I recommend that using the smaller chunks, the bigger chunks have a hard time.
Actually sending, yeah. All right. And is this hearsay?
So, perfect judge, what did you, so starting at
So we're at 75, line 10 through whatever the next thing is, 70, where are we? 78, line 1.
So I don't have any objection to 75, line 10, where Dennis says, what did you hear about them when they tried to shoot Woody? All the way down to line 17, no objection to that part. But when Quindarius asked,
Sorry, guys. I said Attorney Adams. It was Matthews. I'm making the correction. That's the gentleman that's on the side of the court that we usually see right in front of us, Mr. Salt and Pepper. Shout out to him.
he starts talking about when he says, "Oh, you talking about where they got shot at?" And then Dennis
Thanks, Stephanie.
clarifies when they made this post the following day. Zachery says that's when their spot got shot up. That was the next day, though. You're right. And when I think it could be seen a number of ways, but when he says Woody went to the hotel party and basically Kel got locked up when Lucci's mama's house got shot up, and Zachery says, yeah. And Dennis says, right. And Zachery says, yeah. if that portion is being offered for hearsay, if that portion is being objected to on the grounds of hearsay, I would say that that's just a matter of showing a proper foundation. And I would ask that that not be excluded before that foundation is properly laid. If it can't be laid, if we don't lay it, then we don't try to get it in and we don't backdoor it in any way. So I would object to lines 18 through 23 on page 75, lines 1 through 6 on page 76. And as
Okay, well, I mean, that all seems to kind of be like the question on the floor for discussion, right? I mean, they're like saying, okay, what is it we're talking about now?
What are they talking about?
Yeah.
Big Boo is someone who's deceased. But, oh, sorry. Big Boo is someone who is deceased, but what they're talking about him getting shot at, that was not what killed him, to my understanding. But this is all just nothing that Mr. Zachery, to my understanding, has any firsthand knowledge of. And then they talk about Woody getting shot at when he went to a hotel party. That case was never charged. I've never seen anyone say they know who shot at him, and this is just more speculation and hearsay. I have no reason to believe that Mr. Zachery was at that party. And then
I withdraw the objection. I'll stipulate.
Okay, so that carries us through all of 76 or
Then-
down through more, it looks like.
well, then they
Through
start.
78, line 1.
Okay, all of it.
Yeah.
Okay. Thank you. So that entirety of what is represented by our number 20 is redacted by agreement. All right, 21, that's page 79.
As we move on to the next one, I see a few of you guys sending me cash apps. And here's the thing. It's the first time I've ever locked the chat out before, but we missed you guys. This is a little test. Okay. It was a little test, but you guys are doing great. You're almost at 2,000. So I'll go ahead and let you back in. Come on in, everybody. Come on in. We did members only for a little bit. That is the first time that's ever been done on this channel. But we like to be inclusive over here. Some of the best chat that we have is when you guys all contribute and cut up. So I'm letting you back in. Let's go back. And Melnick should be joining us shortly. So I want to make sure you guys are included for that one. So let's get back to it.
Line 14 through 22. Speculation about who shot at Thug's stepdad's house. 14. Yeah, I mean, it's pretty clearly speculation.
Damn Lee
We don't have a
Jr.
Okay, so that is out by agreement. So we pick up from there on line 23 down through 81, line 5.
And that's just, Your Honor, Tyreek, I think there's a gentleman named TJ Rivers.
Uh-huh.
I believe that's his last name. He's not charged in this case. And then Tyreek was his brother, and apparently he was killed by someone at some point.
Yeah, I mean,
has-
that all seems just like, they're kind of like, well, while we've got you in here, what might you know about any other shooting that ever occurred?
Right.
Yeah.
It has nothing to do with this case, as far as I know.
What say you, Ms. Love?
I have no objection to, I'm just going to go down the list. The latter, page 79, 23 through 24. I have no objection to page 80, the entirety of page 80. What do we want to do? And
Dale already starting. He's like, listen, I wanted
Oh.
to cut up.
Page
Now I'm in.
80.
For those asking about the
They're saying
join
81,
button,
line 5. Let's deal with that. I mean, that all looks like
It's hard to find the join button if you're watching from a TV, from a phone. It should be in the description box of this video. That's where I included it. You should also see a black button from a desktop that says join.
So Slug Trontavia Stevens is a member of YSL. He's already entered a plea in this case. And Quindarius Zachery's association, knowledge of, affiliation with Trontavia Stevens. When investigator Dennis says it went quiet for a little while, and then Mr. Zachery, that is, gives this explanation.
Is that supposed to say?
I can go without that. So
All right,
1
so-
through 5 I'll
Okay,
stipulate.
all right. Thank you. All right, and then our next thing is so that one's incomplete, it looks like 81, line 13 through 82, line what, Mr. Sharp?
I think to the end of 82. Oh, well. You know, I would say 82 line 6. Or actually 82 line 3. I don't really have a strong opinion about it. My problem is when the police start talking about ballistics and this matching this. I mean, if it's relevant, that information obviously can come in if it's relevant and you know, fulfills all the other requirements, but that would come in through a GBI expert matching ballistics, not through
Yeah.
investigator Dennis sharing information with Mr. Zachery.
Yeah, okay, so Ms. Love?
I have, if it is, and Judge, I apologize, Mr. Atkins just apprised me our server's down, so he wanted to get my external drive to share those
Okay.
videos with you.
All right.
So I was.
That's okay. So we're talking about 81, line 13 through 82, line 3, and
No objection to the rest of 81. So from line 13 down, no objection to that. So 13 to 23.
no, yeah, no, through 82, line 3.
No objection.
Okay. Thank you. All right. Now we are looking at 83, line 18 through 84, line 21.
That's already been agreed to.
Oh, perfect. Okay. We're looking at 88, lines 1 through 13.
So, Your Honor, let me be clear. This is my understanding. Mr. Zachery, after I read this and then I've since read his other statement. I reviewed them both. I should
Right.
say. I've read them before. But I was unclear if Mr. Zachery was claiming to have been present at the club compound incident. After reading the first in time, second in that I reviewed statement,
Mhm.
it's clear to me that he does claim to have been at compound.
Okay.
My understanding, but there seems to be a blending of what he saw versus what he was told, because my understanding is at some point he flees from the area. He is definitely, by his own words, not on 285 when Lil Wayne's bus is shot. So he can testify, or he has firsthand knowledge, presumably, about things he saw while he was there. But when he says Pee Wee ain't do the shooting, he wasn't there for the shooting. And when he says, I know who left and went behind it though, and he says DK and Shannon. So he's saying Walter Murphy, who's entered a plea deal, my client, went behind Pee Wee's car, Jimmy Winfrey's car. So to the extent that he has firsthand knowledge of things, I concede that he can testify to what he saw. and anything he has firsthand knowledge of that is inconsistent, if he had in fact had firsthand knowledge, he can be impeached. But there's certain things that he speculates, or maybe someone told him, I don't know, but it's not clear to me. So Pee Wee didn't do the shooting. That's a conclusion. He did not witness the shooting. He did not witness anyone do the shooting. So I think that's inappropriate.
Okay, so that is 88 lines 1 through 3, basically. And even the police are like, yeah, we know he didn't do the shooting. So,
And guys, before we get back to it, Legally Shay has just gifted 20 of you guys memberships. She is a lawyer. She's in my home state of Massachusetts, I believe. I think she's either licensed here or she practices here. So this is showing you how many people actually like invest in this community. She doesn't have to do that. She just got out of court. She just got out of court and is watching with all of you and wants to make sure that in the future, if we have a discrepancy with likes, that you all are protected and you have 30 days of being involved in our community. And when you have a membership, we do a lot of polls. You know, first, I have community membership only posts where I will let you guys know if Lead and I are going live. I will poll you guys when me and my editors, because that is right. I have a team. I have 3 people that work for me. This is a business. So I know some of you are like, don't lock me out. But again, this is a business. Okay. So I want to make sure that my editors are doing what they need to do. Legally Shay gets it, and she wanted to do that. If y'all could do me a huge favor, if you received a membership from her, please say thank you. And also at the same time, type in Legally Shay in the chat. That is super, super nice of her. And, you know, to Sister Council, very, very sweet of her. So thank you so much, Shay. Let's go back in.
Well, people in Cobb County would be interested in that, but.
okay, well, I don't know. I mean, maybe they're just saying that to see what he's going to say.
But then he says, I don't know who was exactly in the car. I know who left out and went behind it though.
Yeah.
So to the extent that if he witnessed a cars
Right.
leave compound, I get it.
Right.
But beyond that, things that he did not witness, that's what I'm objecting.
I understand. So I'm trying to kind of take it piece by piece because you're saying he cannot say with certainty Pee Wee did not do it unless Pee Wee was with him at the time.
Amongst themselves.
Okay. Do you have any basis for?
Well, the portion of it where, so Mr. Zachery, like Mr. Copeland, makes assertions about the shooting itself and who was doing what. And the way that the shooting happened is a person is driving down the road next to a bus. And in order to be able to both drive the car and shoot the bus, from the way that both vehicles are positioned, you literally have to have one hand on the wheel, and it was a precarious kind of circumstance that would be needed for the driver of the car, who is Mr. Winfrey, to also be able to at the same time fire the gun and shoot the bus. So in as much as it reflects his personal knowledge of all the people who were there and what was going on, we would argue that his assertion that Pee Wee didn't do the shooting would be subject to a foundation that, you know, we would seek to lay. And I can't say that we have laid that part yet. I think that he is just saying he didn't do the shooting. He was a party to the crime, but he didn't do it. He was driving. He couldn't have.
So is Mr. Zachery in a second car that's involved in this?
So he is in another car, but he's not shooting. He's not in that.
He's not in the shooter car, but he says, you know, me and these other people went the other way. So he's
compound.
right.
Everybody shows up at this one place where
Yep.
the plane is in about 5, 6 different cars.
Okay.
And 2 of them at least follow the tour bus.
Okay.
He is not in one of the ones that follow the tour
Okay.
bus.
But he's there when you have reason to You have evidence that will support that he was there to be able to say at least that as to the car that wasn't, as to some car, the car that went behind it, that he saw who was in those cars?
Yes, he
Okay.
says, Mr. Zachery says, I know who left out and went behind the car, so he
Yeah.
says, and the fact that he's asserting Buchanan Shannon, if he's crossed on that, I would argue that goes, it's way not as a ability of Mr. Sharp.
Okay, but yes, and thank you. But I guess what I'm at, or what I'm trying to get clarification on is Mr. Zachery. It sounds like from what he's saying is he's there when everybody kind of goes in whatever direction they're going. And you're saying that that's his basis of knowledge for who's in what car, right?
Yes.
Okay.
Even at the point where, like in line 14 of page 88, he's saying, me and Trontavious, we don't went the other
Right.
way. Yes.
It sounds like that's all kind of contemporaneous that they're leaving out. Okay, so then I get that there is a basis on which to believe that he has firsthand knowledge to be able to say, I know who left out and went behind it. Who was that? Well, here's who it was. But coming back to the Pee-wee ain't done the shooting, if that's something you want in, then how does he know that? What's your basis for him being able to say that?
At this time, I wouldn't even proffer it. So I would agree to it unless something is said that changes.
Okay.
Because I don't have, there's never been a time where I heard him say, you know.
Okay, so then by agreement then, well then why do we need 2 and 3 and 4? Because they're just confusing without line 1, right? So 1 through 4 are out by agreement. So then 5 through 13, well, 5 through, how about
But 5.
How about that? I mean, the 5 through 9, I see as kind of one little answer that he seems to be able to know. They say truth was with them. What, and then what about that part?
I don't mind 12 through 13 coming out.
Okay.
And guys, it looks like I could get
Okay.
10 free a month. So here you go.
So we're at, the next one is 90, page 90, 11, page 90, line 11 through 90, line 14.
Correct.
We're also hearing that John Melnick has joined the courtroom Zoom.
Those are words of the police.
Oh, Mr. Melnick is here now.
Let's go.
So he's on the Zoom, virtually here. Do y'all all have the Zoom link? I mean, you're welcome to, I see that'll show up on, does it show up on that big screen? All right, so y'all can just watch it on the big screen.
Are you ready for me?
I am. I think I say yes, and yet I think I need to probably turn my camera on. There we go. Hi, Mr. Melnick.
Good afternoon, Judge.
We can't get enough of you. All right, so the reason I have asked again for you to join us, and thanks for doing this by Zoom at very short notice, but so I have essentially determined somewhat with agreement of the parties that we are just going to start over with Mr. Copeland. And he has an immunity. There is an immunity order in place. He has immunity protection. And I plan to bring him in and find out what he wants to do. And I would like for him to be counseled. And I just had him in here a couple of hours ago and asked him if he had an attorney. And he seems to think that you are his attorney still. And so I'm checking in with you to find out whether that is the fact, either still or again, whether you're going to be representing him, because I'm looking for somebody to just ensure that he is properly advised of what the immunity order means, what he could face contempt-wise, what perjury means, what inconsistent statement means, you know, the typical things you would want to advise your client who's going to be a witness in a criminal case.
Sure. So I've talked to him about all that stuff.
Okay. And so are you his attorney currently?
I am his attorney. Yes.
Okay.
Wow.
All right. So, and you're representing that you have in fact already advised him of all of those things.
Yes.
Okay. All right. So I would propose to, unless he just wants to come back this afternoon. I mean, I did think I told him to be available maybe 3-ish. But if you want to be with us by Zoom, but are you available tomorrow to be here in person if we can have him here in person? That way, if he does have questions as anything's going along, and we're not going to take testimony, I just want to find out tomorrow, does he have any questions? Make sure
So,
we
Judge,
clear up a few things and then, you know, find out what his intent is as to whether he's going to testify in this trial or not. We're just essentially going to wipe all of what he already testified to and start over.
Your Honor.
He could be there right now.
Okay.
Oh,
Oh,
good.
he's here right now.
Okay, Woody's
Apparently he's
there.
outside. So,
All right.
do you want to just stand by with us? And if he has any questions?
Sure.
Okay.
Woody's
And, you know,
coming.
Before he's brought in,
Yeah.
I would object to him being asked
Ooh,
at this.
that's mics.
I'm gonna just talk loud. Your Honor, I would object under all of the circumstances for a number of reasons to him being asked at this point whether or not he is going to testify. There have been so that he's made statements. Obviously, the state has brought him in as their witness to proper testimony against people in the courtroom.
Mm-hmm.
And he's made representations, true or false, he's made them regarding concerns that he has. He's made them in previous interviews with investigators, not just you.
Okay.
So, Your Honor, in the interest of not having sort of the opposite effect on him, and I'm not suggesting the court, but I'm just suggesting that perhaps asking him at this point might have a
When do you propose I ask him? Because if you're, I don't know exactly what you are suggesting, and I could be entirely off, but if you're suggesting that he has, are you suggesting he has safety concerns?
Well, he has made statements about people being willing to have him killed.
Okay. All right. Well, to the extent that those might be any of the people currently on trial, he is at some point going to have to sit in this witness
Exactly.
box and say, with all of the defendants present, yes, I am going to testify because y'all are forcing me to because of the immunity order, or I do not care, throw me in jail, you know, essentially. So that's going to have to be in open court in front of everybody. So if that's your objection,
It was just the timing of it.
so would you rather I do it Friday? I mean, what, I don't understand what it is you want me to do.
It was a preference, but I'm gonna, of course, defer to the court. It's just, you know, as I work through everything that I know has taken place,
Uh-huh.
I'm just trying to make certain that the interests of everybody are protected.
Okay, I-
I'm not trying to create a.
No, I understand. And I mean, I'm just not sure what else. I can do it at a later time, but I don't know what that gets us really, other than more uncertainty. And I also realize he may say one thing right now and then another thing right before he is brought out in front of a jury. You know, I don't know. We can still check with him again because we are not at this point having a jury in here tomorrow. So at the point when we get to a jury, if we get to a jury again, then I can ask him again to make sure. I think that would probably be advisable, but everybody's here right now. So I would propose that we do this kind of right now. But before I bring him in, does anybody have anything they want to make sure I make clear with him?
Whew, here we go, guys.
Not for me, Judge.
Okay, so Mr. Melnick, you weren't here when we had our discussions about what was the outer limit of how long the court could hold him if he chooses not to testify. And it is my belief that the longest he could be held would on contempt would be through the end of this trial. So if you need further discussions with him, let me know that.
I don't think so, Judge.
Okay. All right.
And Your Honor, and I know Mr. Melnick obviously knows how to do his job, but he wasn't, and I don't know how much he's reviewed the transcript.
Let me actually ask him, have you reviewed that transcript of the June 10th ex parte?
Mostly. I haven't. I can't say I've sat and studied every single word of it, but I've mostly reviewed
Okay.
it. Yeah.
So, I mean, the defense believes, and I don't necessarily disagree, that there, in addition to a different interpretation of how long he could be held, there is currently a different interpretation of the correctness of the advice about statutes of limitation. And we also think it doesn't ultimately matter because what is protecting him should he testify to something that he did that's criminal is not whether a statute has run or not anyway, it's that he has immunity. But it's possible that a couple of, every statute that you could be worried about has run is not accurate. So, I think you were aware of where in there they said something about a statute, and you're probably aware that there are things he could still be charged with. And does he understand that not every statute has necessarily run on everything he might be criminally involved in, but it doesn't matter because of this immunity order? Or I don't know whether, go ahead.
Yes, Your Honor.
Okay.
He understands.
All right. And then, are you confident that he has a sufficient understanding of what might subject him to a charge of false statements or perjury?
Certainly he does.
Okay. Anything else y'all can think of on either side of the aisle? Okay.
Yes, Judge, can we inquire as to whether or not Mr. Melnick, and I'm sure he has had an opportunity to discuss with him any potential federal ramifications he may have in regards to his testimony here?
Okay. And my interpretation of the immunity order is use and derivative use. But of course, we're not the feds.
And Your Honor, the court has every ability to do this, but I would object to counsel for the defense.
I've asked them to raise anything that they think we ought to be thinking about. So, I invited them to say that. So I don't know whether you want any additional time, having heard that potential issue, Mr. Melnick.
Mr. Copeland and I have had enough time to talk.
All right. Okay, is there a screen where he can actually see Mr. Melnick over there somewhere? Okay, thank you. All right. Let's go ahead and get Mr. Copeland in.
Woody's coming in, guys. All right. Yes, people are saying that he is an informant. That is correct. Let's not forget that he is an informant, but it is making this trial entertaining. Okay. Let's see what he has to say. He did say he did these crimes.
All right. Hello again, Mr. Copeland. Your attorney, Mr. Melnick, is with us by Zoom right now. You can see him on the video screen and he can see you. If there's any time you want to talk to him privately, let me know that. And I know y'all have had an opportunity since you and I spoke this morning
Already.
from the bench in the stand to talk about the fact that the state is not interested in you pleading the fifth. And in order to avoid you pleading the fifth, they have secured an order that says you now can be essentially compelled to testify because we are acknowledging that anything that you say, we cannot prosecute you for a crime other than perjury or false statements based on something that you might say that would otherwise incriminate you if it weren't for this immunity order. And if knowing that you still choose not to testify, the court can and will hold you in contempt. And what happens in that event is that you go to jail. And the length of time that you could be held in jail for if you don't change your mind and say, okay, I guess I will take the stand, is through the end of this trial. I don't know how long it's going to last. I think previous projections had been February or March of next year. I don't know yet, but I guess that's not outside the realm of possibility. But it would only be through the end of this trial. It would not be through the end of whomever else might be severed from this case and tried later. And I know Mr. Melnick's talked to you in more detail about that. So I want to see if you have any questions of the court about that.
I didn't understand. Now you said at the beginning.
Didn't understand anything. All right, so.
No, I'm saying, like, I heard you, but I don't know what you're talking about.
Okay, so tell me what it is that you'd like more information about.
You said something about what they said about immunity?
Yeah.
What you mean?
Okay.
Here we go.
Does anybody, I think I've got the order. Mr. Melnick, have you reviewed the immunity order with him?
Oh, you saying it's the same from last time?
Hang on a second. Yeah, the same one as last time. Yeah,
Yes.
that one. So that's the one I'm talking about. And that is still in effect.
So you're saying that changed?
It has not changed.
All right.
So what has changed is it's my opinion that I cannot hold you in jail if you refuse to testify beyond the end of this trial. I think you had maybe been told something different earlier. And I don't think that is
So I ain't got to wait
accurate.
till every defendant that's not here.
Correct. But you would, if you choose not to testify despite this order, you would potentially be held in jail through the end of this trial, which might be February of next year, might be March of next year. I really don't know. It ends when it ends. And the state has 100 more witnesses, and I don't know, any defendant might also have witnesses. So it could take a while, but that would be the end of it, would be the end of this trial. Okay. So do you have any other questions? Okay. And do you want to talk to Mr. Melnick any more about this particular issue?
No.
All right. So I'm going to ask you right now, because I'm planning to have the jury back on Monday. And I am going to tell them, we would essentially start over, because I want you to have a voluntary, to an extent, choice and knowing choice whether to take the stand and be questioned and cross-examined or not, knowing that if you do, other than if you lie, as Mr. Melnick's discussed with you, and it's something the state knows and can prove, they could charge you with perjury or false statements, but they can't, if you say, if you incriminate yourself about another kind of crime, they cannot use that to charge you with a crime. And they can't say,
Well, can I speak?
you can,
I
yeah,
have
if you
told
have
the
a,
state,
huh?
I have told the state I have lied and lied
I
and
know,
lied and
I
lied.
know. And,
So how is they gonna be able to question me?
I mean, that'll be their problem. That's their case to make or not make. I mean, that's not for you or me to worry about. So
They said they're gonna be able to charge me if I lie. Like when
Perjury.
it's up to them to choose when I'm
not prior. You've said you've lied and lied and lied in every, I don't know what you've said, but let's even say you've said you lied in every statement you ever gave to the police. If you get on the stand and say that again, or if you say, all right, this one was the truth, that one they cannot charge you with perjury for, because those are things in the past. What they might be able to charge you with is, I don't know, I mean, give me an example of something that you know he didn't do, and well, maybe not, never mind, don't do
Can I
that.
give you an example for what they told me?
Yes.
Yeah,
Go.
yes, and then I'll see whether that's what I think or not,
So
yes,
she said that the only reason she won't lock me up, I just want to know if it still applies. She
okay,
said if I do two things, if I plead the fifth and I say that I killed Donovan Thomas.
okay.
Oh,
She said if I don't say them two, she will not lock me up.
All right, what was the first one?
Pleading the fifth.
Say it again.
Taking the fifth, Judge.
Taking the fifth, okay, right. And you can no longer, so taking the fifth means I might say something that gets me in criminal trouble. I might give you evidence against me that you could then use against me. That's what it means to take the fifth, is say, I am not going to give you evidence to use against me to charge me. When they give you that immunity order, immune just basically means we can't do this anymore. It's like if you get an immunization, oh, I'm not going to get the measles now, right? Because I'm immune from it. Because it's like getting you a shot that says, I can say, I can admit to a crime on the stand, they can't charge me with it. They have said, you no longer have a privilege against self-incrimination because we have committed to not being able to prosecute you, not being able to bring criminal charges against you because of what you say. We cannot take that evidence and use it against you. We can't take that evidence. If you say, well, I committed some crime, here's what I committed it with, I buried it in the yard. They can't go dig it up in the yard and then say, well, we've got this. They can't use any of that. So that's why taking the fifth at this point would get you in trouble. Being held in contempt is what we
So what if they don't have
formally call it.
they facts together? Like they saying something that they don't know what they're talking about, and then they ask me about it.
They can ask you about anything they want to. If in your answer you admit to a crime, they cannot charge you with that crime. Now, if you admit to a crime and they have evidence that is pretty certain that you did not commit that crime. For instance, somebody gets robbed yesterday and they have proof that you were in Europe yesterday. There's no way you could have committed that crime, but you say, yeah, I committed that crime yesterday. That was here in Atlanta when they know you were in Europe and they got video of you in Europe and you sent a postcard that said, I'm having fun in Europe. That would be proof that you're lying. And so that they could charge you with perjury for, okay? Or false statements for.
Okay.
Okay? So what I want to know from you is when we have the jury back on Monday and you're still under subpoena, so you're still obligated
Here's the
to
question.
come.
Here
And
it is.
I'm asking you now, when they're like, all right, we're calling Kenneth Copeland, are you going to say, okay, ask me what you want to ask me. I'll tell you whatever I'm going to tell you. Or are you going to say, nope, I don't care if you throw me in jail. I'm not saying a word. I am not getting on the stand.
Here we
Depending
go.
on how I wake up.
Okay. All right,
Oh!
well, then we will just revisit it on Monday morning. So plan to be here at 8:45 on Monday morning.
Wow.
You're free to go for now.
Wow.
All right, Mr. Melnick, please be with us at 8:45 on Monday morning. Can you do that?
Okay.
Thank
I'm
you.
on a trial calendar with Judge Barwick, but I'll notify her what's going on.
All right, thank you. Appreciate it.
Okay, so that's that, guys. There's more to the proceedings. I'm going to bring us back in a moment, but let's just break down what Little Woody just decided to do. We thought this was going to wait until tomorrow. We didn't think we were going to get Melnick today, but in the age of technology and legal technology, if someone is not physically in the courtroom, we could use Zoom. So the judge worked through lunch to get her team to get in touch with Melnick. She did not put that on ADA Love. So now we know that Little Woody is represented. During that lunch break, during the time away, Little Woody did have an opportunity to talk to his lawyer, Melnick, okay? Melnick was advising him of his rights. Hey, you have a choice to make here. You can testify, right? Because I think a lot of people had alluded to this. Some of the guys in the chat were just like, y'all cheering on a rat. You have to remember, Little Woody is an informant. We talked about this earlier today. Tay got killed. This is a pretty serious gang war, right? It is involving his safety. And at one point during his testimony, which is now going to be wiped away, we have to start from the beginning. Everything that we just went through in the entire month of June is now going to restart from scratch. So he's going to be called in on Monday, and all of the questioning is going to start all over. And if you are Simone Hilton, you're on vacation, and you realize when you come back on Monday that you're going to have to question this man all over again. That is what Monday is going to look like. And he says she wanted to ask him before he left this courtroom, I need to know, are you coming back on Monday? And are you going to be cooperative? We're going to call you on the stand. But here are your options. The prosecution team said that there's two things that could put you in jail. Two. One, if you plead the fifth. Two, if you claim to have committed a crime that you did not commit. Why? Because you have hounds of defense attorneys sitting on the other side of that courtroom that are waiting for you to say that. That, my friends, is the Brady violation we've been waiting on. If he says that he killed Donovan Thomas, and think about it for a second. If the world is calling you a snitch, and let's say he says that, this entire case is centered on the murder of Donovan Thomas. Instant mistrial, and some of these guys go free. So you have to really kind of look at the strategy behind this too. He bought himself more time today because he didn't answer her question. And technically what he says, it depends on how I feel, is an acceptable answer. He's basically saying, I will show up on Monday, but it depends on how I feel. That means Melnick and him probably strategically came up with that answer. Because again, it is likely, and I'm looking at the poll, some of you guys are like, do you think Woody, I asked you guys, do you think Woody will choose jail? 63% of you still say yes, that he will choose not to continue being an informant. And does that make up the levels of ratting in the past? And again, Leeds talk to Woody, I never have personally, but like he's been on the channel, right? Now, in the world of street code, I'm going to ask you guys right now. Let's say he takes the fifth and stays in jail and decides not to continue cooperating. Put a 1 in the chat if you think that wipes away snitching, or put a 2 in the chat if you say no, AV, it changes nothing. What does it do? What does it do? Derek is saying he's still an op. Some people are saying still snitching. I am seeing 2s. Keita, I just saw yours too. Some people were 1.25. Some people are the 2s. There's some 2s. I didn't realize this, guys. Y'all are like Chat GPT. A lot of people are saying that it changes nothing because he already talked. And that's the other thing. I just saw it. The chat's moving too fast, but somebody said he will get killed if he says anything. So a lot of this is a big decision for one person. And that's probably why he's been living his best life all summer. It's a big decision to make. Because I think what we've just seen from our poll here, our little social experiment, is that he's always going to be branded as somebody that told. And these guys have been sitting in jail for 2 years. Does that take away that actual people have been victims of crimes in the Atlanta area for years? No, it doesn't take away from that. Does that take away from the fact that people got murdered? No, it doesn't take away from that. But now you guys see how intricate this is, because even if he sits in jail, he's not safe in a jail cell and he's not safe on the street. So he's getting his money while he can, and he just bought himself how many days of time? Wednesday, Thursday, Friday, Saturday, Sunday, Monday. He just bought himself about 5.5 days of time. He's a dad. Maybe he wants to spend a few days with his family. Who knows? But I think what's important for you guys to realize, this is the moral of the story, and I really want to continue today's day and look at Love's demeanor throughout the day and see what they're going to do with the witness that they plan on bringing up after Woody, because it is likely Woody is going to do one of these two things. He's going to plead the fifth and just take that time and stop, and he's just going to do the bid. Or two, he's going to say that he killed Nut. And if he does that, you know these hounds on the other side, and I'm saying that in a good way. They are like wolves. They're salivating. They're like, oh, go ahead. Say it. Say that you killed Nut. Instant mistrial. This is getting serious, guys. It really, really is. And this poll is good, because I think as a social experiment, you have to think about that. However, here's the other thing. And I saw this on Instagram. Somebody tagged me in it yesterday. I was looking at it through the break. I think there was one of the leaders of YSL has been, or co-founders of YSL. I can't remember the guy's name, but had tagged like a video of me and Lee talking about this. And we were reading a document that showed how many times Lil Woody had testified, not testified, but at least was in the detective's office as an informant. And, that YSL person was kind of like, listen, he still caused a lot of damage to a lot of families, a lot of lives, just by saying what he was saying. And Lil Woody, you guys just saw him say, he literally just said, why are they trying to prosecute me? I told them I lie about everything. Do y'all want to watch it one more time? Let's go back, because that was only about 5 minutes. I want to watch it one more time, just from a legal lens and legal perspective, to listen to it and to kind of parse out the strategy, because Melnick looked a little too chill. I'm going to bring it back again. It was about 5 minutes while he was up there. Okay, here he is. Let's go back.
All right. Hello again, Mr. Copeland. Your attorney, Mr. Melnick, is with us by Zoom right now. You can see him on the video screen and he can see you. If there's any time you want to talk to him privately, let me know that. And I know y'all have had an opportunity since you and I spoke this morning from the bench and the stand to talk about the fact that the state is not interested in you pleading the fifth, and in order to avoid you pleading the fifth, they have secured an order that says you now can be essentially compelled to testify, because we are acknowledging that anything that you say, we cannot prosecute you for a crime other than perjury or false statements based on something that you might say that would otherwise incriminate you if it weren't for this immunity order. And if knowing that you still choose not to testify, the court can and will hold you in contempt. And what happens in that event is that you go to jail. And the length of time that you could be held in jail for, if you don't change your mind and say, okay, I guess I will take the stand, is through the end of this trial. I don't know how long it's going to last. I think previous projections had been February or March of next year. I don't know yet, but I guess that's not outside the realm of possibility. But it would only.
And look, guys, like, remember, that was one of the first questions he asked the judge when he sat down around right before lunch. He said, am I going to have to do time for just this trial? Or like Judge Glanville and the prosecution's team said to me, because they want my testimony so bad, am I going to have to do that plus the severed defendants? And there's a ton of severed defendants. Some of you guys have watched those hearings with me. I counted like 6, 7 dudes. So that can add up to over 50 years. Look at this man's body language. She just answered his question and he's looking down. He knows that there's a big decision to make here. Let's go back in.
Be through the end of this trial. It would not be through the end of whomever else might be severed from this case and tried later. And I know Mr. Melnick's talked to you in more detail about that. So I want to see if you have any questions of the court about that.
I didn't understand. Now you said at the beginning.
He said, I didn't understand anything you said at the beginning, but he paid attention to what she said towards the end, because that is the question that he had. Okay. She was trying to explain that in the past, there was this misconception, like I just said to you guys, that he would have to do both those pieces of time, the end of this trial and severed defendants. But what she did do is she answered his question. That's what he was paying attention to. Because remember, when he looked down, he realized what the answer to that question was. Let's go back in.
Didn't understand anything. All right. So.
No, I'm saying, like, I heard you, but I don't know what you're talking about.
Okay. So tell me what it is that you'd like more information about.
You said something about what they said about immunity?
Yeah.
What you mean?
Okay. Does anybody,
Okay, now that's the thing. Before he came back in, she was just not fighting, but going back and forth with ADA Love. You guys, that was this stream right here, this stream that we were just watching. If you rewind it back, she was just going back and forth with what immunity, the type of immunity that Lil Woody has been granted by the state. There's use immunity, and I forget the other term off the top of my head, but there were 2 types that they were grappling with. And the Judge Whitaker here was like, we need to be clear. I want to see the law. I want to see the statute. I want that to be super clear before he walks into this room. And we need to explain that. Mr. Melnick, are you clear? Have you explained that? Mr. Melnick says yes. Okay. Now Woody is asking again on the stand, what type of immunity do I have? Y'all talking about immunity. Can you explain that to me again, Judge? Here we go.
I've got the order. Mr. Melnick, have you reviewed the immunity order with him?
Oh, you saying it's the same from last time?
Hang on a second. Yeah, the same one as last time. Yeah,
Yes.
that one. So that's the one I'm talking about. And that is still in effect.
So you're saying that changed?
It has not changed.
He was looking for an answer.
So what?
He's saying, so you're saying nothing has changed. He was looking to see if something has changed with that type of immunity. Did y'all clear that up? Did y'all clear what type of immunity I have? And she's saying, okay, we've clarified it, but that immunity has not changed. He's aware of what's going on here a lot farther than we think that we do. And let me say this because I've been covering this for the past few weeks, and people are like, oh, when you make statements like this, are you saying that Woody is not a smart person? Are you coming at? No, I'm not. I'm explaining to you guys what the law means. And I'm also showing you through human behavior and body language, because that is also another big part of being an excellent trial lawyer. Understanding human behavior, behavioral science, and body language. You can see he's following. But I think what he's thinking about is his concerns to help him make the decision that is probably one of the biggest decisions of his life that he needs to make. Right? Let's keep going.
What has changed is it's my opinion that I cannot hold you in jail if you refuse to testify beyond the end of this trial. I think you had maybe been told something different earlier. And I don't think that is
So I ain't got to wait
accurate.
till every defendant that's not here.
Correct.
See, there's that question, right? So that was his main concern. His main concern is what the prosecution team scared him with. They probably scared the living shit out of him with that. Like, you're going to spend the rest of your life in jail. Granted, he took a big gamble by, choosing to be an informant. That's a whole other topic for a different day. He already made that choice, and he's seen the repercussions for what? The last 9 years? Those conversations, those jailhouse phone calls, those detective interviews, all of those things took place in 2015 onward. So the last 9 years. So now it's coming full circle. Now you could see the comprehension happening, but now you could see where his mindset was and where his concern was. So let's go back in and see how this dialogue continues.
But you would, if you choose not to testify despite this order, you would potentially be held in jail through the end of this trial, which might be February of next year, might be March of next year. I really don't know. It ends when it ends. And the state has 100 more witnesses, and I don't know, any defendant might also have witnesses. So it could take a while, but that would be the end of it, would be the end of this trial. Okay. So do you have any other questions? Okay. And do you want to talk to Mr. Melnick anymore about this particular issue?
No.
All right. So I'm going to ask you right now, because I'm planning to have the jury back on Monday. And I am going to tell them, we would essentially start over, because I want you to have a voluntary, to an extent, choice and knowing choice, whether to take the stand and be questioned and cross-examined or not, knowing that if you do, other than if you lie, as Mr. Melnick's discussed with you, and it's something the state knows and can prove, they could charge you with perjury or false statements, but they can't, if you incriminate yourself about another kind of crime, they cannot use that to charge you with a crime. And they can't say,
Well, can I speak?
you can,
I
yeah,
have
if you
told
have
the
a,
state,
huh?
I have told the state I have lied and lied
I
and lied and
know, I
lied.
know. And
So how are they gonna be able to question me?
I mean, that'll be their problem. That's their case.
I don't know if that's the best thing she could have said right there. That will be their problem. What, Judge? That's the first time I've kind of seen Judge Whitaker say something a little questionable. Like, it's almost like, let's put it off. Like, let's cross that bridge when we get there, so to speak. That'll be their problem. And I think he actually has a legitimate question. Like, how is something like this allowed to go down in our legal system if I've told these people that I have lied and lied and lied and lied and lied? And shout out to Legally Shay. I think I saw her say this earlier. The jury is responsible for looking at his credibility, but in a sense, the prosecutors, they need him for this case. They need him so bad that this man has been, it sounds like coerced, but at the same time, if he was a willing participant, a willing informant 9 years ago, and now he changes his mind that he doesn't want to do it anymore. When we did our social poll, I saw a lot of twos. I saw a lot of you guys say that doesn't negate anything. He's got himself in quite the pickle here. But let's go back in.
To make or not make. I mean, that's not for you or me to worry about. So
They said they're gonna be able to charge me if I lie. Like when it's up to them to choose when I'm lying.
not prior. You've said you've lied and lied and lied in every, I don't know what you've said, but let's even say you've said you lied in every statement you ever gave to the police. If you get on the stand and say that again, or if you say, all right, this one was the truth, that one they cannot charge you with perjury for, because those are things in the past. What they might be able to charge you with is, I don't know. I mean, give me an example of something that he didn't do, and well, maybe not. Never mind. Don't do
Can I
that.
give you an example for what they told me?
Yeah, yes. And then I'll see whether that's what I think or not. Yes.
So she said that the only reason she won't lock me up, I just want to know if it still applies.
Okay.
She said if I do two things, if I plead the fifth and I say that I killed Donovan Thomas.
Okay.
She said if I don't say them two, she will not lock me up.
All right, what was the first one?
Pleading the fifth.
Say it again.
Taking the fifth, Judge.
Taking the fifth, okay, right. And you can no longer, so taking the fifth means I might say something that gets me in criminal trouble. I might give you evidence against me that you could then use against me. That's what it means to take the fifth, is say, I am not going to give you evidence to use against me to charge me. When they give you that immunity order, immune just basically means we can't do this anymore. It's like if you get an immunization, oh, I'm not going to get the measles now, right? Because I'm immune from it. Because it's like getting you a shot that says, I can say, I can admit to a crime on the stand, they can't charge me with it. They have said you no longer have a privilege against self-incrimination because we have committed to not being able to prosecute you, not being able to bring criminal charges against you because of what you say. We cannot take that evidence and use it against you. We can't take that evidence. If you say, well, I committed some crime. Here's what I committed it with. I buried it in the yard. They can't go dig it up in the yard and then say, well, we've got this. They can't use any of that. So that's why taking the fifth at this point would get you in trouble. Being held in contempt is what we
So where they don't have
formally call it.
they facts together, like they saying.
So let's stop, because earlier when we watched that, I didn't stop and explain that, guys. I hope it makes sense. Like, she just explained the difference between immunity and taking the fifth, right? What she is saying is, hey, you've been granted immunity. So even if you take the fifth, do you see how that becomes an issue? Because when you take the fifth, it is used as a constitutional protection so that you do not incriminate yourself. What she's saying is you have immunity, right? So you have the shot. So regardless, you have this, you're immune from any crimes that the prosecutors can bring against you. That's how bad they want his testimony. A lot of you guys have had questions about that in the last 48 hours. Hopefully that clears it up. But I'm going to go back about 10 seconds because Lil Woody is about to ask her another question.
So where they don't have
Formally call it.
they facts together, like they saying something that they don't know what they're talking about, and then they ask me about it.
They can ask you about anything they want to. If in your answer you admit to a crime, they cannot charge you with that crime. Now, if you admit to a crime and they have evidence that is pretty certain that you did not commit that crime. For instance, somebody gets robbed yesterday and they have proof that you were in Europe yesterday. There's no way you could have committed that crime, but you say, yeah, I committed that crime yesterday. That was here in Atlanta when they know you were in Europe. And they got video of you in Europe and you sent a postcard that said, I'm having fun in Europe. That would be proof that you're lying. And
That's what it is, guys. So that's the thing. If he says, and that's why Simone had given them those two options. If you take the fifth and if you admit to killing Donovan Thomas. Why? Because it is likely that the state has something against one of the defendants that's proving that one of the other defendants did it. So even if Lil Woody comes in and starts admitting this stuff, like she said, okay, let's use the example of, you say you committed a crime in Atlanta, but we have proof that you're in Europe. They might have something on either one of the defendants or Lil Woody that proves that he did not kill Nut. I don't know what it is. We're going to see. But it is interesting because so much of this is centered around Donovan Thomas's murder. This whole case, half of these RICO charges are tied to Donovan Thomas's murder. And Lil Woody kind of screwed himself by talking about Donovan Thomas's murder. And now you see him kind of contemplating some really big choices. Let's go back in. I want to see his reaction after she explained this.
And so that they could charge you with perjury for, okay? Or false statements for.
Okay.
Okay? So what I want to know from you is when we have the jury back on Monday and you're still under subpoena, so you're still obligated to come, and I'm asking you now, when they're like, all right, we're calling Kenneth Copeland, are you going to say, okay, ask me what you want to ask me. I'll tell you whatever I'm going to tell you. Or are you going to say, nope, I don't care if you throw me in jail. I'm not saying a word. I am not getting on the stand.
It depends on how I wake up.
Okay. All right. Well, then we will just revisit it on Monday morning. So plan to be here at 8:45 on Monday morning. You're free to go for now.
Interesting.
All right, Mr. Melnick, please be with us at 8:45 on Monday morning.
Wow, what do y'all think? I mean, second watch for those that stayed with us. Second watched. You know, I mean, some of y'all have questions. You're like, what if he runs away? He's under subpoena, so he can't. He'll be arrested if he runs away. Some of you guys are saying he does not have credibility. You know, people are saying he looks a little shook on the second glance. What is it going to do to time? I mean, these are interesting observations. Full tethered. I mean, he going to jail. Y'all are saying he's going to jail. Maybe he goes to Europe. Who knows? You know, like this is gonna be interesting, guys. But I wanted to take some time to really parse through what we just saw. We've been waiting for that moment for some time, but the big moment's gonna be on Monday. This is the first time he's been in the court. And remember, the jury was not in this room today. The judge wanted to be sure. They spent days yesterday, today, last week, parsing through evidence to make sure that we are prepared for what he is about to do. And some of y'all are like, hey, you know, he might get, shout out to Kayla, unalived in jail. And, you know, that would be a tragedy, but it's just, you know, Ton saying it. He's screwed either way. I think he knows. And that's the other thing. The defense wants to talk to him. Ash says he's nervous. Some people are saying he's going to choose jail. You know, that poll's still going. Y'all are at 63%. Man, oh man, this is going to be crazy. SWAT says he's still trying to get that 20 verse 1 money on YouTube. I don't know. Retta says she doesn't feel good about this. Sherry says she's seen him on other channels and he's pretty articulate compared to what we see sometimes. People are asking me what I think. I don't know. I think this case has a lot of twists and turns, you know, and also I don't know the Atlanta street. You know, if you ask me about Boston, like, you know, I grew up here. I could tell you some stuff, even though I'm a little bit more on the white collar side. I can tell you some stuff because I grew up in the city. But as far as Atlanta, it's been pretty new to me. I lived down in Buckhead recently up until the last month, and I moved back up here for some school stuff. But I don't know the city enough to be able to give you a proper assessment. And I haven't seen Miss Fifth Floor. I haven't seen the evidence myself to make an assessment. Some of y'all are saying that he didn't do it. You know, I'm just very careful. Hello world. I'm very careful. You know that. All right, guys, let's continue on with the trial. They're likely have taken their afternoon break. I want to see what they're going to do. And guess what? Looking at the TiVo action, they took a break.
I'm on a trial calendar with Judge Barwick, but I'll notify her what's going on.
All right. Thank you. Appreciate it.
I think they took a break right after Woody.
All right. So there we have our answer to the extent we have an answer. We will revisit this on Monday morning, which is, by the way, when I plan to have the jury back. And we at least, I have some degree of confidence that he understands what his choices are and what his consequences are.
That's right.
Okay, back to Mr. Zachery's testimony. Everybody good? I mean, I know we just took a break. Anybody need a break before we dive back in again? Yes, all right. I didn't take a break before, so I could use one now. Let's take 10 minutes. Be back at 5 after 3.
All right, so we have some TiVo time here. I'm going to speed us up ahead to when they return from the break. That puts us about 15 minutes behind the live feed. Let's keep going.
Okay.
Kelly, what about Simone?
All right, so I think we are on page 90, lines 11 through 14? Okay.
I just realized I was talking on mute. You guys know I do that all the time. Just realized, just before we go back in, I just wanted to give you guys breaking news. As of 5 minutes, Brian Steele has filed an additional motion to have the prosecutors taken off of the case. That is as of 5 minutes ago. Let's go back in.
That's law enforcement speaking, basically saying that how Shannon involved in everything. So when they hear his beef, it's almost like call Shannon. That's the detective.
Mm-hmm.
And then the other detective follows it up with Shannon, the shooter.
Yeah.
Now, I will say on page 90, line 14, I should add this. I've reviewed all these statements and I've written notes where I feel that the transcript is insufficient. And my notes I have on 90, line 14,
Mm-hmm.
Underwood, investigator Underwood says Shannon the shooter. And then Dennis says because, and then Underwood says Shannon the shooter again.
Okay.
So that's my objection, is the police
All right.
labeling my client the shooter.
Well, the answer is good for your client.
I understand that, but I just,
But yeah. All right. What does the state say?
Your Honor, it's a question,
No.
it's not an assertion.
No.
They're asking is Shannon the shooter, and the inflection given by any person repeating it wouldn't do as much justice as listening to it.
Well, I will happily listen to that as well. But even if line 17 is a question that is saying Shannon the shooter,
Right.
then we probably could just go with line 17 and not like the 11 through 16.
So.
What do you think?
So 11 through 13, we would object to being excluded because that's Detective Dennis asking of Mr. Zachery something about one of the defendants currently on trial based on Mr. Zachary's relationship with him and affiliation with him. I don't have any objection to 14 through 16 coming out.
Okay.
That's what they want, but we would ask that the court, I think Mr. Atkins has had an opportunity to send a link to the, no, he hasn't. He said it's taking 31 minutes.
Yikes.
So I may be able to, I don't know if.
I mean, if y'all have it and could just pull it up, I can listen to it right now.
You can do that.
then also bring it to you.
Talk into your mic, please.
On line 21,
Yes.
Investigator Dennis, my notes say, where it says indiscernible,
Uh-huh.
says about that action.
About that action?
Yes.
Okay.
Speaking of Shannon.
Let me ask y'all, are y'all actually providing a transcript to the jury when you play these statements?
I believe we may have done it once, not with everyone, but I did intend that we clean up the ones that we have and provide a copy to the defense and see if they disagree with any
Okay.
cleanups and allow the jury to use the transcripts because they tend to prove helpful, but that we hadn't gotten to the cleanup part yet. We haven't cleaned it up entirely, and sometimes if the defense has a transcript they'd like us to use and like us to use, we welcome that as well, but right now.
Okay. And I don't know if the defense would have any kind of a position on whether on that issue.
There's a lot of issues with these transcripts, a whole lot, and just in all honesty,
Okay.
Your Honor, I don't see how we could agree to a transcript without all of us just sitting in here and
Well,
going
yeah.
through with a fine tooth comb.
No, I agree. And it may come to that, but it may be, a lot of times, I think when audio video is played, at least in my courtroom upstairs, there are a lot of times when it's hard to hear. It's kind of like muffly. Even if I take it in my office and listen on my computer and I can hear it crystal clear, for whatever reason, once it gets out here and gets played through, whatever, it's not as clear. Now, maybe down here in 1C, it's a better audio video system and everything's been clear. But I guess if it comes to it, we'll sort it out then. But
Judge, I can, on behalf of Mr. Williams, I can tell you at this point that we're going to object.
like I hear this voice who is talking. All right.
Is God.
Yeah.
No, I can tell you now that on behalf of Mr. Williams, we're going to object to the jury being provided any transcripts.
All right,
based on
and
everything
what-
that's happened so far.
What would the basis of your objection be?
It's been our experience thus far that we just have significant disagreement with the state
ATL vibes, yes.
on the transcripts that they're provided thus far. And we
Okay.
think, quite frankly, it's better for the jury to make their own determination about what's being said.
Okay. All right. Well, and I mean, it just may be that as we go on, if and when one day this trial wraps and a jury is deliberating, they may want to hear a whole lot over again, and we'll just all have to sit here and listen to it too. So y'all know that, and if that's what happens, that's what happens.
And Your Honor, we would also posit that there is the instruction that the court could give the jury about the transcripts not being evidence, and that they are indeed supposed to listen and take what they hear versus what's written on the piece of paper as
Sure.
evidence.
Yeah, I mean, so I just was raising that to find out, had y'all already come to any kind of an agreement? What was the practice here with this trial? So it sounds like if you want to do that, first off, you need to endeavor to the extent possible to come to agreement on what a transcript says. And then second, if it's necessary, I will sort out whether I'm going to permit that or not. And I'll listen to the legal reasons for or against. But okay, so if you can tell me, I know that first thing you gave me 27 minutes, 30 seconds. So for this one, where would I be listening? Oh, we'll play it here. Never mind.
We need the Zoom link.
Oh, it's the same one as it was a minute ago when Mr. Melnick was on.
I think this is the video she was asking for that they dug up. And this is preparing for the next witness after Woody. If the
And for
trial
this-
continues.
Because the only sound appears to be coming out of those two little strange white speakers, can y'all turn one my way? And I think that may be the subject or the reason for the squelch, but I'm not going to be able to hear it otherwise, unless somebody wants to come up with a speaker that I can have up here with me.
Thank you, Amira. I owe you a response. I'm sorry. I'll get to you. Yeah, I'm gonna start this, Marie. A lot of people are asking this.
Judge, could the court give me just a minute? I'm trying to get it open and then
Yeah.
trying to get to that point.
Okay. And as long as we're going to do this, we might as well listen to both of the ones, and I don't care which order we do it in, but
Not yet, Bob. That was a bombshell, so I needed to wait. Yeah, while they're figuring that out. I have not read super chats yet, guys. I'm kind of just starring some of your questions, and I will go through them. But Woody came literally after lunch, so I wanted you all to see that first, and for us to get into the discussion. So if you sent a super chat or a cash app, I will get to it during our next break or when there's a free moment in time. It looks like we're listening to a video of the next state's witness. What is his name? I wrote it down earlier. This is his interrogation video. So my notes from earlier. Oh, this is Quindarius Zachery. This is what we were kind of going back and forth on earlier. The crappy thing about the state's witnesses is that most of this has come in while people are taking plea deals and they're watch out for their own backs or taking care of themselves and providing information into the state's case. I mean, this is giant. It's a RICO thing. Like there were 20 defendants at first and over 100 witnesses, and we got it down to 6 defendants, but some of these defendants have severed, from the bigger group. They've severed themselves so they can have independent trials. So not only is the prosecution working on these 6 defendants for RICO, but they have other
Y'all
trials.
can go ahead. I mean, look, is the video matched up with the audio when y'all are showing video in court, or is there a lag?
Sometimes there's a lag if we use a server, but if we do it from a hard drive.
Okay, so that's what y'all been doing, is using a hard drive?
We've done both, and
Okay.
that's what happened.
All right. What are we gonna be doing right now?
A hard drive.
Okay, perfect. Because honestly, sometimes it helps to see what they're saying in addition to listen.
That's a good point, MJ.
What is this? Transcript.
Yeah, Bilal, I think that's what a lot of us are getting at. Like he is saying, I did these crimes. I'm lying to everybody. Like this is fucked up. Like, he's basically saying that. And we're all watching history take place in the state of Georgia. Most expensive trial in the state's history. Resources, these poor jurors can't find other jobs. They have to do this thing. I mean, luckily they've been off for the last month. But you see that the prosecution has made many mistakes and the case is still moving on. And so many of you guys, just from the outside looking in, like as spectators, we're all like, how is this possible? How is it possible? So it's really sad. It's really sad. But, again, if this gives you guys a little bit of hope and faith, is there's still 2 motions that are outstanding. Actually 3 now. Brian trying to get Love and Hilton off. So the prosecution's off the case. A motion for mistrial has not been granted. Weinstein put that in. It's been a week and a half. She hasn't ruled on it. And then lastly, Stillwell's motion for a fair trial. All of that's happening. Even Huey's got one for to be severed. He's still holding on. He doesn't want to be a part of the 6 anymore. That's Bruce Harvey's client. So we've still got some pending motions that haven't been charged yet. But it looks like the judge, she said she's going to plan to bring that jury back on Monday. She's planning to continue where we left off, even given some of the administrative issues we've seen all of last week. Super, super interesting. I'm going to speed us ahead and see if we can get some extra time out of them. It is muted right now because they don't want the public to hear the content of this video. Well, it's likely that we'll hear it next week. Let me just keep skipping. Let's see if we can catch up. Yeah, they're still listening. And what they're trying to do is match up his statements in the interrogation video to what is on the transcript. It seems like they're having a problem with it because we can't hear anything.
Which one are we targeting first?
The one on page 90.
Okay.
I'm just trying to get. So where we are, the line he's at right now is the line 25 on page 89.
Okay.
So if I may, I'll just.
Sure, that's fine. Yep.
Oh, here it is.
So Slug ain't go on the bus? No. Well, I told you, he grew up, he know that. He got to he grew up, he don't know that no more. But you said Shannon. How Shannon get involved in everything? So when they hear his speak, it's almost like call Shannon. Because that's what they say because. Shannon too. Now, Shannon always be quiet. Right. He did. Yeah. When it comes down to it, he's not scared. Who shot Shannon? Who shot Shannon? They say he smoked. I don't know. I walked up.
All right.
Is it jail? I read through jail.
I heard what I need. That's definitely a question. Shannon the shooter? And then the answer is no. He was quiet. So
Ah.
17 is fine to be in.
Can the court remind me of the one before?
Yes, so that was with regard to item number 13. And y'all said it was around 27 minutes, 30 seconds. And I'm wondering, and we may need to play more of it than that, because I was asking, who is the they that they're talking about?
No, this was
And
the
I was just gonna
day.
maybe listen a little bit
That does
in front of
oh,
that.
boy.
But then, yeah, so anyway, that was the issue there. So I don't know how much we're gonna need to listen to find out who the they is. Or if we can find out who the they is. But your item number 13, which was on page 54, but I'm thinking we need to go find the beginning of whatever this portion of questioning is. There's a whole lot of days in here.
I think that it would be helpful for the court.
To just have the whole, listen from the beginning. That's fine. I'll do that. That'll be my homework.
Does the court have, or Ms. Percival have a thumb drive? Because I can easily just copy it onto that thumb drive. That's probably the easiest thing to do.
Probably not here, but definitely in my actual chambers. We've got one. Maybe Miss Bugs could bring us one down before we finish for the day. Okay.
Oh,
All right. So
looks like we're almost.
I think that answers our, on our number 25, which was page 90. We were gonna, by agreement, strike 14, 15, and 16, because you can't hear what they're saying anyway. But leave in, not by agreement, leave in 17 and 18. All right, so. Okay. All right, that takes us to 92, line 11 through 94, line 22. Dennis, who's Dennis? It's investigator Dennis. Okay.
So. Okay.
So it's not the entirety of 92. That's just to give me context. Is it when, is it 93 line 21 where the real objection starts?
There's none.
92 line 15.
So investigators.
Oh, if y'all don't mind turning those speakers back around now so we don't have squelch.
So, Matthews, bring around the corner. Bring around the corner.
Thanks.
Yeah, that's right. That's good.
Okay.
So investigator Dennis was present. He was working an extra job at Club Compound, and he's already testified. And he's provided live testimony about what he observed at Club Compound. Right here, and I think admittedly in the statement, he's just kind of going off his memory and he's confused, and he's testifying about. I mean, not testifying, but he's talking to Quindarius about what he saw.
Right.
And we've already heard from him sworn in court testimony about what he saw that night. And this is, in several of the interviews, he goes into what he saw that night. And I just think it's inappropriate for the jury to get investigator Dennis's version of events through unsworn out of court statements. And they're likely to confuse it with what he said on the stand.
Okay. So can you pinpoint for me On page 92, is there anything? Well, I guess line 15, like.
Right, he's leading into it. He's talking about DK, who's Walter Murphy, and I believe it was Pokey. That's Kaikendo, and he's actually wrong about that. Fatty is Kaikendo. And so he's just kind of setting the stage of the people he saw. And then,
Starting at where, 15?
15.
Okay, yeah.
and then he's talking about the gun that
Right.
DK had a gun and he recovered the gun
Right.
and how he pulled out his gun and Jeffrey's sister Max took offense to it and how the gun was put on Dolly. Dolly is Max. That's the same person. It's on Dolly's truck.
Yeah.
And so he's just reliving what he observed that day. And I just don't think it's appropriate for it to be played in an out of court
All right.
statement like this.
What's the state's response?
Your Honor, with respect to the sections about Detective Dennis relating and receiving input from Mr. Zachery, information about the Little Wayne bus shooting, as Mr. Sharp said, Detective Dennis was there
Mhm.
that night, and as he relayed what he saw, Mr. Zachary's reactions are the more important thing. Obviously, the jury has heard Detective Dennis on the stand, and particularly at line 93.
On which page?
I'm sorry.
Oh, page 93, line.
15 through 17, for instance.
Uh-huh.
Where Detective Dennis says, but DK had a gun. I recovered a gun from DK that night. And Zachary says, yeah, I saw that. So Detective Dennis's words impact on Zachary and his responses to them are the more important thing than us trying to have him, as Mr. Char said, testify. That's not what we're trying to do. Now, there are parts of these that we don't have a problem, consenting to.
All right, well, tell me what those parts are.
Well, let me.
Or the opposite. Tell me what parts you really maintain you want / need / believe you're entitled to get in.
So starting with taking out, I don't mind page 92, lines 11 through 25.
Okay. Well, so we'll redact that by agreement.
And I'm sorry, I missed what the court said.
I said we'll redact that by agreement.
Page 93. Lines 1 and 2.
Okay.
We would object to page 93. Lines 3 through 6, 3 through 9.
Okay, so that you believe should be in.
Yes.
All right. And
And that's because as investigator Dennis is talking about cooking off Betty and DK being like this, Mr. Zachery is making his assertions about who among them was actually there.
so he's actually showing I've got knowledge of this and,
That's
okay.
our position.
All right. Any response on the 3 through 9 of 93, Mr. Sharp?
No, I'm
All
fine
right,
with that.
so that is then in by agreement, essentially. All right,
As we go on further down,
and then
I have no objection to 19 through 23 coming out, where investigator Dennis is talking about cookie dolls, not cookie dolls, but DK's gun having been taken.
right, okay. All right, and so up above then, where he's saying DK had a gun, I recovered a gun, yeah, I saw that. Is he literally mean, yeah, I saw that on the scene?
Yes.
Okay, yeah, that seems like that could come in. All right.
So lines 24
Mm-hmm,
and 25 on 93 lead into
mm-hmm.
page 94, lines 1 and 2.
Okay,
We would object to that coming out.
yeah, I mean, that seems like that's still the firsthand knowledge.
We have no objection to page 94, lines 3 through 6 coming out.
Okay. 3 through 6,
Actually,
3 through 7.
well,
Or-
yeah, 3 through 7, that's fine.
Okay.
They really do need to change this angle.
Lines 8 through 10. And we would object to that coming out.
Okay.
We would object to line 11 through 18 coming out.
Mm-hmm.
We don't, actually, we would object to line 19 through 25 coming out as well. Specifically, where only that Detective Dennis said lines 19 through 22,
Right.
but then Mr. Zachery gives.
Is sort of agreeing and yeah, okay. All right. Any further argument on basically like lines 8 through 25, Mr. Shart?
No, Your Honor.
Okay, all right. I'm going to permit that in.
And so
So is everybody clear on what's out and in, or do you want me to, good?
I'm clear.
All right.
So the next section, Your Honor, is kind of picks up right where we are. And I flagged this because it was unclear to me at the time whether Mr. Zachery was claiming that he was there. But I am satisfied that he is claiming that he was at the compound, but I think we need to review it with the knowledge of where he was at the compound and where he wasn't.
Okay.
What is based on firsthand knowledge versus what is speculation.
Can you speak to that, Ms. Love?
Which part are we talking about?
I mean, essentially like through the 94 line 24, I guess through 96 line 14.
So my first issue is on 94, he says, yeah, she swapped cars with with who? DK and Shannon. Okay, if he saw that, that's fine. You know, if he, of course, if the foundation is laid to ever play.
Right.
But then after he says DK and Shannon, investigator Dennis says are shooters, and Quindarius Zachery says, yeah. He wasn't present for the shoot.
Okay.
It's going back to, he has no firsthand knowledge to affirm investigator Dennis's theory. So I would have a problem with lines 1 and 2. And then I have a problem with investigator Dennis, who was present, saying
Right.
Pee-wee in the white Camaro was just a driver. He doesn't know that. So I'm going to start out 95, 1 through 4.
Okay. So I think essentially that one is, okay, this is the law enforcement theory at this time, but
So we're starting on 90.
95 lines 1 through 4. Or, yeah.
At this time, Your Honor, well, I'll put it this way, for open reserve, if I ask that the court allow, if we are able to establish that foundation, then I'd ask that the court not exclude it.
Okay, and that foundation being the foundation that he actually does have.
Personal knowledge of it
Okay,
for some other.
okay, or, okay. Yeah, so that one is, I guess, a TBD.
And Your Honor, I want to also say, so with respect to Mr. Zachery, he has, and the reason we have some TBDs by some of this
Uh-huh.
is that he he has not been the most cooperative person,
Uh-huh.
and, I would leave it.
Oh, wow.
Okay. All right, so
Another uncooperative witness. Hey guys, so here's what we're gonna do, because I'm just thinking about what we saw with Woody's testimony. You guys are giving me a ton of ideas. So what I think we're actually gonna do, I need to start getting these ideas to my production people ASAP. And I'm just looking at the time. It's about 4 o'clock, and I don't want to keep you guys watching more testimony for the next upcoming witness when we're really trying to get ready for Monday. So here's what we do. I'm going to read a few super chats, and let's just game plan this because there's a few things. So Lee could not join me today because he's a little under the weather. So we took care of today's stream. It is likely we'll be back tomorrow if he's feeling better. We will be streaming together then. What I want to do is go through these supers and then get to my production team ASAP, because I have a video up here, and it really is just kind of thinking about what y'all are saying as far as like how the prosecution team has royally fucked this up. So I need to get that script on paper, and I need to get it to my guys so they can start working on it. So let's do this. Let's read the supers. I'm not going to subject you guys to, what we're doing with love. Somebody had me crying earlier because they were like, oh, her outfit today reminds me of Dora the Explorer. And I literally almost fell out of my seat because you see the pink and then we see the orange on the bottom. So shout out to the person that said that. That was hilarious. Am I not sharing it? Let me see. Hold on. Do Dora, swiping. It's Dora. That had me crying earlier. That was hilarious. So let's read our supers. And for this afternoon session, all of them have been read right now. So if you dropped it really early on. So for example, shout out to Shannon, who drops $9.99. She dropped this at 1:35 p.m. and we're almost at 4 o'clock. So Shannon, thank you so much. What does Shannon say? Shannon says, I'm with you, AV. Love's pants are burned in my eyes. Maybe we can gift her with a longer suit jacket. Thanks to AV and TLA. Appreciate the coverage and commentary. Thank you so much, Shannon. And not, again, like that's the intention. It's like we want you guys to learn about the law and learn something, right? So hopefully that happened. Red Bunny Classic with the 2 Canadian bucks says, huh? Hashtag Woody. Yeah, that's the first thing he said when he got on the stand. Couldn't believe it. It was just like, huh? It's hilarious. Red Bunny Classic became a member. Lakeisha became a member. Lacey became a member. Rebel became a member. Thank you guys so much for becoming a member. And again, I never lock people out on this side. I did it today, more so along the lines for a test. This is one of the biggest audiences I've ever had. But I think we'll probably keep it open moving forward, because I know some of you guys are like, I don't like that. But again, I have a team. I have people that work for me, and they gotta get paid. Shout out to DD with $5 who says, oh snap, AV pulled the TLA move and locked him out. I did. It feels weird because I never do it. It's like your first time. It feels a little weird. Shout out to Ree who says long-term support, sis, huh? She's laughing. Shout out to Andrew with the 5 who says, NAL, I think love's right, but requires different procedure. We would have to be held in contempt in each individual trial for not testifying. Yeah, I mean, she won that. I think I remember what you're talking about now. She ultimately lost that argument. The judge is saying that Lil Woody should not be held after this trial. And I think it was not Adams. It was the other attorney that came up, Mr. Salt and Pepper on the side. He came up with a case that was directly on point. So that was the save of the afternoon. Corey became a new member. Jack gifted 5 memberships. Jack, thank you for doing that. That was really, really nice of you to do. Chelsea dropped a $1.99 who says they value Woody's testimony more than his freedom. They do. And that's what's really sad about this. TRT drops $9.99 who says the AV to the 7th power. That's right. I'm here all day and yesterday too. Sick day cooking again. $1.99 says, can they use immunity on the next trials? I don't know if I understand the question. If Woody has other trials in the future, I mean, because if he has immunity, he really can't get in trouble for his past crimes and current crimes. Isn't that crazy? Shout out to Miss Cheney, 89. I think we were born in the same year, sis. She became a member. Christy became a member. Ms. Roberts the third Sent a super sticker. Thank you so much. April V became a new member. Miss Roberts sent a super sticker. Thank you for the $5 super sticker. Mitch drops 5 and says Lead should represent Woody. We've been talking about that all day. That would be something, right? The Little Gaming Channel with 10 says the cleanup of this case shows how incompetent Glanville was. If he's this bad, he needs to retire. He allowed this shit show. He did for far too long. Could y'all imagine if we still had Glanville presiding over this case? I don't know. We would have shouting matches all the time. The prosecution would be getting away with all types of shenanigans. Shay B dropped a 5, says 4.2K watching. Y'all can't back out of the chat. Click the like button. Hello, it's free. They ended up getting there. Thank you so much, Shay. Shout out to Sharon's Flair with 199. She says, hi, Ivy, keep up the good work. Thank you so much, Sharon. Papa V became a new member. Miss Roberts III with another super sticker. Thank you so much, Miss Roberts. No weapon formed against me with 5, says small soda to go with the chips from earlier today and appreciate you. I appreciate you right back. Thank you so much. No weapon formed against me. Miss Roberts again with the $5 says that this was never a good case. Facts are everywhere. TRT says the AV to the 7th power again. And yeah, like I'm going back to Miss Roberts for a second because the facts are everywhere. I mean, it's just, they should have never been tried as a group. And I think that's what everybody can see from this case. You know, they should have been tried either individually for their individual crimes, but they wanted to come after YSL so hard. Who knows what the reason is, but super, super interesting. The Little Gaming Channel back with another 10. It says, people, this is how a fair, structured judge works. Her time management is awesome. It's really good. It's a huge improvement from Glanville. Legally Shay became a new member before she gifted 20 AV memberships. TSOJ gifted a membership. Look at Michelle. She gifted a membership. TSOJ gave out another one. Then Miss B she became a member. You guys have really, really been showing each other love today. I really love this community. Natalie dropped the 199 super chat. Shout out to you, sis. Bilal hit me with the 2. And then look at me. It's me. I'm shouting on myself. I didn't know that as a creator, I can give you guys memberships. I think it's limited to 10 a month. So because we had a big crowd today, I gave 10 of you guys a membership. So I hope you enjoy them. Jackie dropped $4.99 and says UNTLA are my medication and or drugs. Also, no mistake on multiple. Oh, $1.99 super chats. I was excited to catch the live and read the chat. Awesome, Jackie. I'm glad that you have fun today. Really appreciate that. And again, your stream sponsored Legally Shay gifted an additional 20 memberships. And guys, she's been doing research as we've been doing this. So much respect for our solo practitioners. That means that Legally Shay is a lawyer and she has her own practice by herself. She doesn't have partners or anything, but she was in court this morning and tuned into our stream. So thank you so much, Legally Shay. And I think that put her at 40 memberships for the day. Extremely generous, extremely generous. So welcome to the community, sis. And thank you so much for doing that. Anthony drops 10 and says, they, them, those are general pronouns. If used during interrogation, would it behoove the state to clarify pre-indictment? Oh, you using we had a guest dog? Oh, yeah. Yeah. You know, that's the thing. The state could be careful with their choice of words. We just went through this yesterday with Kayla on the stand, and then Lead gave a pretty good, masterful class on how to use pronouns last night, at least from a legal standpoint, and the importance of doing so in the courtroom. So thank you so much, Anthony. Tiff says, is TLA coming when Woody comes in? Yeah, he was out sick today, Tiff. So that's why you didn't see him on the screen. Hopefully we're back tomorrow. Gail Marie dropped $2. Thank you so much, Gail. Shay B is back with another 2. She says, is Melnick really his lawyer? Looks like it. Oh, wait, Shay. Is he? Are there other people advising? This is an excellent question, Shay B. That almost went over my head. I'm happy I came back. JC says, dear Woody, Nancy Reagan says, just say no. Judah Rising, thank you so much. Judah drops 2, says, what happens if little Woody says he killed Nut? I think we've covered that already. They seem to have, it's not going to end well if he says that, number 1, to answer your question. But number 2, they are likely to have evidence against someone else that actually committed it. So if he says it to try to take the L for the entire YSL group, it's just not going to end well because they have proof that he didn't do it. So he could be guilty of another crime, which is perjury. That's why they pulled the perjury statute. That's why they went through the perjury statute before he came up, because they knew the likelihood that he could likely do that. And we're going to see on Monday. He's either going to say that or he's going to plead the fifth. So we'll see what happens. It depends on how he feels. Shout out to Ray, not Charles, with the $2 says, "What you mean?" And could y'all believe he came up there saying that? It was so interesting. Carson with 199. He says, "This is a hot mess, isn't it?" Shout out to Leeds Weighted Blanket with $4.99. It's so funny. Somebody said that he looks like Sam Cassell with an oral BBL, and this troll is interesting because that is actually a photograph of Sam Cassell under a blanket. Okay. It says, "I'm watching with Lead. He's so excited. He's massaging his ashy feet together like Birdman under here." Y'all are hilarious. Thank you so much, Leeds Weighted Blanket. And welcome to the chat. Patrick dropped $4.99, says, "Judge for like gum, but she is sucking or smacking on something to chill Line's breath." Yeah. So earlier the judge was like chastising someone for chewing gum, but like there was a point after the afternoon break. I don't know if it was a cough drop or something, but she was nibbling on something. It was all up in the microphone. Did y'all hear that? It was crazy. It was crazy. Thank you so much, Patrick. Leeds Weighted Blanket comes in with $1.99. He says, "Freedom over 1, 2, 3, 5th." That is funny. Thank you so much, Leeds Weighted Blanket. Scott A is back with $4.99. Says, "Woody is smarter than you guys think. He knew by saying that he would plead the fifth, he would be locked up immediately. He got himself 6 more days free." Yeah, I think he did that to buy some time. Shout out to Eva. Thank you again, Scott. Eva drops 10, says, "AB, why is the judge giving the state so many redos and second chances? Why does she keep trying to fix the state and Glanville's misconduct? Not fair to the defendants." I agree. Let's go to your first question first. Why is the judge giving the state so many redos and second chances? She's giving them redos. She's giving them second chances, but I really think that she's doing that for herself and to be fair to the defendants, because we did get a few things cleared up. And you know, you may not see this on the face of it, but we caught the prosecutor in a few mistakes yesterday. And we also caught them in mistakes today. So she gave them redos, but she also let them redo and give them enough rope to hang themselves and fuck up. And they did, which is good in a way, because now we know they did not properly advise Lil Woody of his rights in that ex parte hearing. They didn't. And that only came out because this judge wanted to go through a redo to bring herself up to speed, because she's got a mountain of motions that these defense attorneys have been filing for months. And now there's finally somebody that will listen to them. So Eva, it's actually kind of a good thing. Now, second question, why does she keep trying to fix this state and Glanville's misconduct? Because she has to. She has to, because it's still like the way that Glanville and the prosecutors were doing this, they've made too many mistakes where it does impede justice, right? To the point where Brian Steele was faced with contempt. That went all the way up to the Georgia Supreme Court. And they, pretty much said, no, he's not going to jail. What are you doing, Glanville? This is like 3 layers above him. So everyone is watching Judge Whitaker right now. And that's why she's playing it very close to the book. And the world is watching Judge Whitaker right now. So she almost has to remediate things, because in the interest of justice in the state of Georgia, she has to. How would you feel if you were in again, as a former resident of Fulton County, I wouldn't want to get arrested there. I wouldn't, because I just want to make sure that if I'm processed through the legal system or the criminal justice system, that I'm going to be treated fairly. Do you think defendants are able to say that right now after watching everything we just saw? Yeah, no. So excellent questions though, Eva. I really appreciate the thought behind them. And thank you so much for the super. Shout out to Demi with the 279 Canadian bucks. And the question is, do they have protective custody on Woody? As far as I know, I don't think that they have PC on Woody. They have offered, whenever he's called to testify, they have offered to pick him up and drop him off at different locations, because I think Simone had said he didn't have transportation at one point. I don't know if that's still the case right now. They have had discussions with him about it. He has gone into hiding over the years. So I don't know if that's the case right now, but certainly I'm pretty sure that it would be the right thing to do to protect himself. But Woody himself has kind of leaned against it. Shout out to Bob Gable with 199, who says, does the state have a case without Woody? Could be quick. No, I don't think they have much without Woody. Even the new witness that they're trying to bring in right now, what is the Q name? Quintavious? Is it Quintavious? Quindarius. Yeah. So they're saying that he is, they're having problems with him cooperating too. This is going to take forever. It's going to take so long. It really is. Thank you guys all for the supers. I'm going to come over to the Cash App side just to make sure I'm not missing anything. I got a few over here. Shout out to Liz. This is on the lunch break. She says, she sends $1. She says, I'm not mad at you. You know what I'm saying, Liz? You know what we're talking about? Shout out to Jason, All Pro. Jason sends $5 who says, I am still alive. Good. Jason, I think I remember you. I think you were going under a pretty serious, medical thing soon, in the past. I'm glad that you're okay. Blessings to you and your family. I'm glad that you're okay. Thanks for tapping in. That's super nice of you. Liz is back with $1, says now Woody is going to choose jail. I mean, he just might, but I think his safety, he's between a rock and a hard place, but it's because of his past choices, so we'll see what happens. But thank you so much, sis. Shout out to Kim with $5. And this is why I unlocked the chat. She says, for the lock in the chat, please. And I think I had unlocked it right when she sent that. Shout out to Alicia who sends $5. She says, I love it here. I'm glad you like it. Yeah, and that brings me all up to speed. So again, guys, I'm going to call it a day for right now. Keep an eye out for me and Lee tomorrow. If you don't see us, it seems like the rest of the plan for court, because I'm not listening to what they're saying right now, I can't really give you a game plan of what. Whoa, hold on. Did I miss one? Where is it? How come I don't see it? Whoa. When did that come in? Guys, can we shout out Viva Wood Life? When did that come in? Did I miss that? Viva, if you're here, I'm so sorry. Can y'all type Viva in the chat? Why aren't you loading? I don't see your super chat here, but I see it on this side. And it says, AV, good job. Little Woody was granted immunity from the state. I imagine he could still be in jeopardy from a federal perspective. Is that the case, or what are his options? Excellent job. And guys, Viva is a huge, and I'm going to make you the stream sponsor. Thank you so much, Legally Shay. I'm going to keep your name up there, but I really want to shout out Viva. I don't know why it's not showing up on my side, Viva. I almost missed that. And for that, I apologize. But Viva is he's Unc of this community. He just dropped $100, but he is usually very, very active on lead side, super active on my side, and ask some really, really great thought-provoking questions so you can see, right? So Viva Wood Life, y'all can type Viva Wood Life in the chat. That would be fantastic. And let me go back to the question so I could properly answer it. So Little Woody was granted immunity from the state. So he has that on the state level. I imagine he could still be in jeopardy from a federal perspective. He could, if federal charges are brought against him. Is that the case? And what are his options? Well, it is the case. So to answer your question, Viva, you're absolutely right. And his options are this. There are certain, when you have crimes that you commit, it depends on where those crimes are brought against you. You have them on the federal level and you have them on the state level. Sometimes you'll hear us talk about double jeopardy, meaning that you cannot be charged for the same crimes twice. That is more on, it's a constitutional right. That is something that lands in criminal procedure on the federal side. But here he has immunity on the state side. Now, let's say there's an unrelated crime, right? And this is what Little Woody was kind of hinting at, because he was asking about the statute of limitations on murder. Now, this is a state crime. If the feds wanted to jump in, is he still in limbo? Yes, but it would have to be a different set of operative facts and crimes not connected to this one per se. So let's say if it's Nut and someone else is charged with it, or Little Woody is kind of involved with it. It's coming from the same set of operative facts, right? That's probably a very tired answer coming from me, at this point in time. And I'm sounding like Judge Glanville, but I wanted to make sure I caught your questions, Viva, and hopefully that answers them. But yeah, guys, listen, I'm going to skate out of here. Thank you so much for typing Viva Wood Life in the chat. I appreciate that, brother, so much. He has no idea. So many of you guys have been holding it down all day. Look at MG Law, another fellow attorney in the chat. And people are saying, yeah, it's been there for a bit. I don't know. It's not showing on my other side. And it's not showing at all. Like usually when I bring them up, it shows here, but not on the other tab. And you know what I'm talking about, MG. It's not showing up as starred. Very weird. So Viva, I'm glad I caught it before I left, because that is extremely generous of you. He says, it's all good. I'm enjoying the stream. Shout out to the chat for the love. Yeah, thank you guys for shouting out Viva. Lisa, yes, we got Woody today. You got to rewind, Lisa. All right, guys, I'll be honest. I am tired. I did 3 streams yesterday, 2 on my sides, 1 with lead, 2 today, and I need to get my editing team the direction and the production direction that they need. So I'm going to sign out. Stay safe out there. On to the next one. See you soon. Bye.